Lordship, this criminal jail appeal 107 of 2017 was heard by Lordships, and the judgment was passed on 27/7/22. Therein, I had taken a plea that the appellant was mentally not sound. Lordship dismissed the appeal, but then Lordship gave a direction to the Lakhimpur jail superintendent to get the accused appellant examined. Lordship. Day before, I have received this examination, this letter from jail superintendent, and he was examined, and it was found that he has psychiatric problem, Lordship. So, Lordship, in that view of the matter, maybe from the jail he will have to be shifted to the mental hospital, Lordship. Though the case is disposed of, Lordship.
So, would you do one thing?
Yeah.
It will be appropriate if you file a misapplication, because the disposed cases now it will be this must be a division bench.
Yes.
So we will be, functus officio, and so we will not it would amount to any observation made at this stage. So we, as a sequel, will pass the order based on our earlier direction and the report which you may include in the application. I suppose you were serving as a amicus, so yes. All whatever necessary assistance.
Yes. If I have to file a IA,
yes,
his signature I cannot take, Lordship, because first of all he's mentally not fit to sign a affidavit. Lordship, then I'll have to file the appeal. IA.
Yes. Let the letter be written. Okay, the letter is there. Okay, you do that. We'll see. There is no issue.
No issue, Lordship. Okay.
We'll take it up because as per CRPC, we'll check it up.
Yes.
Whatever is provided.
He will have to be shifted to the Tejpur hospital, mental hospital, because he cannot stay with the other. Correct.
Convicts. So, in what capacity you will file the application? We will see that.
Okay, I'll file as an advocate, but as a amicus.
Yes.
Okay, fine.
Yes.
Highly obliged, Lordship.
May I please, Lordship?
Yes.
I'm praying for listing of a matter in the motion column, Lordship. This was listed earlier, Lordship, but because of some typographical error, we are asked to correct it. And since last 4 weeks, it is not being listed, Lordship.
Motion column, which matter?
Motion, Lordship. It's a repetition, Lordship, regarding foreigner matter.
Will come up.
Next week, Lordship, we need it.
Motion is a motion matter.
Yes, Lordship. Motion.
Yes.
May I please, Your Lordship? Your Lordship, may I please, Your Lordship? Your Lordship, I beg to mention item number 28 of today's daily list, Your Lordship.
28.
28. Your Lordship, kindly the matter be adjourned for the day.
28. What is 28? Commission. There. Yes, what do you want?
Adjournment, Your Lordship.
On the prayer of Mr.
S. Paul.
S. Paul, counsel for the petitioner. Let us stand adjourned to how many days you want?
1 week, Your Lordship.
List after 1 week. Yes.
Oblige, Your Lordship.
Yes.
May I please, Lordship? Lordship, we have filed a writ petition, Lordship. This matter may come up for motion on Friday, Lordship.
We'll see. Will come up once you have filed. It will come. Don't worry. It will come up.
Some urgency is there, Lordship. That's why, Lord.
Will come up. We will see whatever.
Lordship, next week, any date, Lordship.
So it will go. Yes, next week. See, we are not fixing any particular date. They will check up.
Obliged.
If there is any issue, let us see. If there is not listed, we will see. Because let us go by the computer, by the registration. There may be some problem. We don't know. We'll see that. Yes.
I beg to mention one admission matter, my lord. Already elder sister's case is disposed of by this honorable court, my lord. Same set of documents and same set of witnesses, my lord. The 2017 matter. Elder sister case already disposed of by this.
Anyway, we'll see that. We'll see that.
And
We'll
next
see
week,
that.
my lord, any day.
Huh?
And next week, my lord, any day.
No, don't say next week like that, because there are a lot of matters. Don't expect anything next week. We'll first try to take up these matters, then we'll see. We will not add anything new to the existing list. We will see. Once the list gets exhausted, we'll you give the list, we will see
Obliged.
according to the yes.
May I please, your lordship, my lord. My lord, I filed one additional affidavit, my lord, annexing some certain, my lord, documents, my lord. In respect of the, my lord, writ petitioner, my lord, his elder brother was declared to be an Indian citizen. Therefore, my lord, the final opinion of the, my lord, younger brother was, my lord, annexed in the additional affidavit, my lord, in the month of July, my lord. Lordship will kindly fix a date, my lord. After, my lord,
We
2
will
weeks
come up. See, let us not see. Don't ask for date like this. Let us go chronologically.
my lord, that I understand, my lord, my,
So let us
I
go
filed it in the month
chronologically.
of July, my lord.
See,
It has
we'll
not been
go
listed.
chronologically. We'll see. Let us not try to jump queue. Let us maintain the queue as far as possible.
My lord.
It's not like that you are going to be arrested or something like that, or any such contingency. That's a different thing. Otherwise, let it come chronologically.
My lord, I approached before the concerned registry, my lord, but till date it has not been listed, my lord.
No, it will be listed.
My
Why not? It will be, check it out why it is not listed. But listing will be as per the chronologically, the filing.
My
We'll see that. Will come up.
Matter of 2017, my lord, it is also declared.
Correct. We'll see that. We'll see that.
My
There
lord,
already matters have been listed already, because then we'll have a supplementary list.
my lord.
Okay. Yes.
May it please your lordship, I beg to mention item number 27 of the daily list. In this
Yes.
petition, lordship, there some clerical mistake with the annexures. We want to withdraw this petition with liberty to file a fresh lordships.
What is your name?
S.A. Borboya.
Mr. S.A. Borbhuya, learned counsel for the petitioner, prays for withdrawal of this petition with liberty to file a fresh petition on account of certain defects in the petition. Praise aloud.
Deeply applied, lordship.
May I please, my lord?
Yes.
Lordship, prayer for listing, my lord. One item of 2019, my lord. Any date, my lord.
Will come up. Will come up.
No.
Now let us see that will come up. Another list will be prepared. Once the listed matters be taken up.
My lord.
Okay.
My lord.
Otherwise, will be a confusion.
My lord.
Because all government advocates, they also come prepared with these listed matters. Let us see whatever is listed, we can't help it. What is listed, listed.
Right.
We'll see. Will be taken up.
Right.
Yes, next.
Daily list for motion item number 1.
May I please, my lord?
Yes.
Yeah. My lord, in the present case, my lord, during the trial, my lord, prisoner adduced herself as DW1. My lord, he to establish a link with her parents, my lord, she adduced one certificate issued by the Gambura, my lord. The Gambura is appear before the tribunal, and he also deposed that he issued the same, which is proof, my lord. And my lord, his elder brother and younger brother also deposited before the tribunal, but the tribunal discarded the Gambura certificate as, my lord.
Records have reached. Records have come. LCR. Records have come. Then we can fix for hearing.
My lord, petitioner not in interim, my lord. That is the only problem, my lord. And my lord, last time,
Artist.
last date, my lord, Honorable Honorable Lordship has observed that, my lord, there is some discrepancies in the reference, my lord. That's why the court also allowed the petitioner as well as the respondent to go through the record, my lord. But I could not go through the record. my lord.
When you want to go through record, you go through.
Yes,
If you
my-
want,
my
go
lord,
through.
my lord.
It will be taken up next week.
My lord, any day.
Okay. Or Mr.
KM Hassan.
K.M. Hassan. He is permitted to go through record as he may go through record as permitted earlier. List a matter after a week.
My lord, date may fix, my lord.
After a week, the corrected do. After a week.
1711.
My lord. Oblas.
Item number 2.
Maybe lordship, my lord. In this case, my lord, the input order, my lord, is 61, my lord.
They also, we have seen the records.
Yes,
have
my
been
lord, and
received.
interim period will be considered after receipt of ulcer, my lord. Notice was not issued in this case, my lord, also. My lord, what are my 25/7?
Parties to the proceeding shall go through a relevant record. Have you gone through a record?
No, my lord.
You want to go through, it's up to you.
My lord,
There's a
notice-
order, it's up to you.
Notice, my lord, go then.
Oh, there is already a direction of this
Yes, my
court.
lord, but 25/7, there is also direction, my lord. The interim 25, my lord. Can you see
Correct.
that?
You want the interim to be heard without going through record or not? That's what I'm saying. We are saying.
My lord,
Since there is observation that
my
parties
lord,
of proceeding
at
shall go through relevant record. If you say you don't want to go through record, then okay, we'll hear. But if you say you want to go through record, then you take it.
At this is the,
That- Up to you. We are not compelling you to do it.
my lord, at this is that we are not ready to go through the reports. So, my lord,
You don't want to go through the record.
yes, my lord. The notice may go and the petitioner international. And all the discussions will let yes, my lord. And petitioner the name with his mother's, my lord, and subsequent voter list, my lord. Kindly smell in input order, my lord.
You have been on bail so far?
No, my lord.
You are in detention or what?
In outside, my lord.
During the proceeding, were you on bail or not?
No, my lord.
What?
We want to bail,
We-
my lord. He is not in bail, my lord. The petitioner is not in bail, my lord.
During the during the trial, he was in bail. Otherwise, he could not have appeared.
That's what we said. Therefore, during the trial, therefore we are asking. So you were on bail. You would
Yes.
have been on bail. Otherwise, the tribunal would have asked you to surrender or something.
Yes,
like-
I want to bail, my lord. That is,
Huh?
yes, my lord.
So during the trial, you were not in detention.
Yes, my
Huh? Okay. During the proceeding, and when was the order passed?
My lord, order was passed, my lord. There's 61, my lord. 6/5/2022, my lord. 64. Order date, my lord.
6/5/2022.
Yes, my lord. Kindly, my lord, see the observation my lord, from 68, my lord.
Yes.
My lord, they calculate, my lord, the presence age and the original birth days. So there is discrepancies, my lord. That is the appropriate, my lord. Kindly one annexer 1, 2, 3. All this type of calculation, my lord. He said in 97, his the petitioner father was say 45. So 70 minus 45. His birthday will be, my lord, will be at 1982, 1920. In this way, my lord. So everybody will be that kind of, my lord, defective, my lord. Yes. Nobody will be accurate, my lord, because the voter list,
What are the documents you have relied upon?
my lord, all the voter list, Gaubura document and land document also, my lord.
Gaubura document, Gaubura was examined.
My lord, my cousin brother was examined and land document, my father's, my lord. And my name also recorded with my mother, my lord.
Where is it showed that?
Yes, my lord, page 27, my lord. And my father was expert 1980.
Page 27.
Yes, my lord, my mother name, sir, and my name. My mother is 60 years, page 27, my lord. Earlier, my father name is recorded. But
Anshuma Khatun.
yes, my lord.
And what is your name?
My lord, Aswaruddin.
Asaruddin.
Yes, my lord. And subsequently, all the voter list, my lord.
1997.
Yes, my lord. And I was.
And
the-
prior to that, any voter list?
Yes, my lord, that is my father, my lord. Also, my mother also 83, my lord. That what, my lord. And 89, my lord. Next
Eh, eh.
95. Next
And who is the 70? Who was in 70?
70, my lord, my father voter list.
Father, what is your father's name?
Asaddar Ali, my lord.
Asaddar Ali.
Yes, my lord.
97. Okay.
And 66 also, my father name.
Yes, Mr. Pine, there appears to be at least
My lord.
prima facie nothing. We are not,
Prima
we'll
facie.
examine, we'll not do any detailed hearing.
That's my lord. Prima facie, my lord, your lordship may kindly see his father's name is there. Karim father's name is there in 1970.
Yes.
And in neither in the 1970 nor in the 1975 voter list, his mother is there. Only in 1997, when his father is there, mother is there along with the.
We'll examine that
So
because
first of
he,
all, my lord, if she is the mother, original mother of the son or daughter of that particular person, the
No, no,
mother
see-
and father name should
no,
have
no,
been
no,
there in the
see,
same voter list.
just see.
It is not there.
No, no, come to page 27.
Yes.
Come to page 27. Musamman Ansuma Khatun, husband late Asadar Ali.
That's not
Asadar
also-
Ali is there
I-
in
I understand,
1970.
I have no dispute on that.
Then
His some Asadar Ali is there. Now, who is this Asadar Ali? Is it the
yes,
son
we'll
of
examine.
My
We'll
lord,
examine.
my lord may kindly.
See, we cannot examine in the motion
No,
stay
no,
the
no,
entire
my lord,
correct.
As your lordship is considering the bail, my lord, what I'm pointing out, my lord, in 1970 or in 75, if father and mother were there in the same voter list, I had no objection.
No, father was
All-
expert 98, 90.
I accepted, my lord. The mother is 60 years in 1997. Mother should have been there in this 1975 along with father.
On Mr. H. Ali,
Yes, my lord.
and a counsel for the petitioner. Also Mr. Pine, line of counsel for the state. Others also, your presence will be recorded, huh? Miss Naam likhna. Miss Devi. L Devi, na?
She is for central government.
Name, sorry. J. Sharma. J. Sharma is central government. L Devi for,
Maybe for NRD.
yes.
You would should be
Is-
appearing for respondent number 5, madam.
Sorry.
I'm for respondent number 5.
Yes. As observed by this court earlier on 25/7/2022, interim prayer for the petitioner for the prayer of the petitioner for grant of bail has been considered on perusal on receipt of the record. We have gone through, we have had a counsel for the parties, we have also gone through the record. We have noted that the name of the petitioner appears along with his purported mother, who is stated to be the wife of one late Asadar Ali, whose name and the name of the said Asadar Ali is also found in voter list of 1966 also there.
Yes,
I
my
think.
lord. 66,
60,
70.
70. Under the circumstances, we have the view that the matter requires to be examined, during which period the petitioner may be allowed to remain on bail if not already detained in terms of the impugned order dated
5/6,
5/6.
22, my lord. 6/5, 6/5.
Accordingly, the petitioner allowed to remain on bail in connection with the so case number. In case number so. However, he'll appear before the SP border
Hojai, my lord.
Jai and furnish necessary bail bond and furnish bail bond rupees 5,000 rupees with security of like amount to the satisfaction of the SP border Hojai. The SP border Hojai will also capture the biometrics
Yes,
as well as the fingerprints,
yes.
and the petitioner also will inform the SP border Hojai in the event of his leaving station by informing him with the particulars of his place of visit with the relevant mobile contact number.
My lord, my lord, in cause and title, my lord, district, it was wrongly written by Nagar. That may be allowed to correct my lord. Hojai, my lord, it will be Hojai.
Hmm?
It will be Hojai, my lord. In cause and title, my lord.
In the course title?
Yes, my lord. Only district, my lord. The deputy commissioner written Nagar, it will be Hojai. My lord. That may be allowed to correct, my lord.
But it is written Asabuddin district Hojai.
Yes, my lord, Hojai, Hojai, my lord.
Huh.
But in question title, deputy commissioner, it was my lord, respondent number. Written as Nogao, it will be Hojai only. Only that part, Hojai only.
Okay, page 3, okay. Mr. Ali submits that because of certain typographical mistake, the deputy concerned deputy commissioner has been wrongly shown as deputy commissioner Nagaon. The correct designation, the description of the deputy commissioner, the correct description of the said respondent would be deputy commissioner Hojai.
Hojai, SP also Hojai. Both are Hojai. my lord.
Why do you make this all this,
My lord, it is
it
actually
adds so
earlier,
much
my
to our,
My lord, it was earlier Nogao to so that is my lord. Sorry, I am that.
Hojai, district Hojai.
District Hojai, SP Hojai.
Similarly, the Superintendent Police B Hojai has been shown as that of district Nagaon. The correct description will be Superintendent Police B Hojai, district Hojai,
Yes, my lord.
Assam. Pin so and so, huh? Pin will लिख देना. The said mistake is allowed to be corrected by hand.
Hello, Krishna.
Item number 3.
Lordship, may I?
Yes.
Lordship, this petition is filed seeking a direction from this honorable court for
Yes.
the payment of arrears of the revised pension of the petitioner, Lordship.
Yes.
And pursuant to Lordship's order, actually the arrears have already been released.
Okay.
But there are some minor differences in the calculations that is provided by the account section of this High Court, Lordship,
Okay.
and the arrear that has already been released to us.
Okay.
I have given the papers, Lordship. Let me just have
What
a
is the
look.
difference?
The difference is a minor, Lordship,
How
it's
much?
just rupees 14,000 and the petitioner is okay with it, Lordship. So he prays that the petition may be closed.
Okay. And we will close it with liberty to apply for correction. From I don't think government will deny you that 14,000 because of mistake. Whatever is that, we will give you the liberty.
Lordship,
Yeah.
Lordship, and this is just an approximate calculation. So
Okay,
the
very well.
petitioner is not pressing on that.
Okay, very well.
Yeah.
We still will give you the liberty. I don't think, yes, Central Government Council, these mistakes in calculation, it happens. So if that, because mistake is mistake, isn't it? Especially if it's a mathematical mistake. It is not a judgmental mistake. Judgmental mistake, the only option is to go for review or appeal. But this mathematical mistakes can be always corrected by way of review, isn't it? Typographical mistakes. Okay. Had Ms. D. Saikia, Lieutenant Counsel for the petitioner, are also Mr. B. Chakravarti, Lieutenant Central Government counsel appearing for the respondent 1 and 2. Anybody else?
I
Talukdar.
appear for respondent number 4 on behalf of Mr. UK Nair, Lord.
Also, Mr.
I'm MP Sharma, Lord.
MP Sharma, learned counsel appearing on behalf of Mr.
UK Nair.
UK Nair for respondent number 4. Anybody appearing for respondent number 3?
Lordship may record name of Mr. R.K. Talukdar for the
Okay,
appeal.
okay. Also, Mr. R.K. Talukdar, learned standing counsel. For accountant general, I suppose, huh? Accountant general appearing for respondent number 3. Ms. D. Saikia, learned counsel for the petitioner, submits that the petitioner has received the amount which was due to him. However, on close scrutiny, it was found that there is a minor discrepancy of about 14,000 roughly, which is a discrepancy of 14,000 about which the petitioner would be entitled to. However, otherwise, the petitioner is satisfied with the response of the authorities in releasing the due arrears. However, it has been submitted that if necessary, the petitioner may be allowed to write to the competent authorities for correcting for releasing the correct amount. Full stop. Under the circumstances, we are also the view that since the petitioner has been granted the relief sought for, except for the minor discrepancy which may have occurred due to miscalculation, we allowed this petition and close the same with liberty to the petitioner to apprise the authorities of any such discrepancy, so that if the amount is found to be less, if amount released the petition is found to be less than what is actually due, the authorities will do the needful for releasing the correct entitled arrear pension.
Deeply obliged, Lordship.
With the above observation, the present case can be disposed of.
Item number 4.
May please, Lordship. Lordship is Lordship, second round litigation, Lordship.
Sorry?
It is a second round litigation here, Lordship. The earlier, the petitioner declared final, Lordship, approached this court, Lordship, page 60, Lordship. Court
Page?
remanded, page 60, High Court order, Lordship, paragraph 4.
Yes.
Paragraph 4.
Yes.
Lordship, therefore, while rendering the opinion, the learned tribunal has the duty bound cast upon the learned tribunal to give finding on the considering of the evidence on record, including queries made the learned tribunal to the witness. Hence, the court is opinion that the non-considered evidence available on record has to is the party. And that's send
Paragraph 4,
Lordship, page 60.
you are reading which paragraph?
Paragraph, Lordship, paragraph 4, last part.
You said that.
Sorry, Lord, the last part.
Paragraph 4, last part.
Lordship.
Therefore, rendering duty bound. That's right. Oh, and we intend to interfere with the impugn business. Like to pass fresh opinion. Yes, there was
Lordship,
direction to.
Lordship, but
Then-
what happened in the present opinion, Lordship, did not discuss about the High Court order, Lordship, and say almost same opinion is passed, Lordship, without discussing anything, Lordship. Discussing the evidence of the opinion number 1 and 2 is stated that, but no reason is given, Lordship.
Let us see that order, impugn order.
Lordship,
Page.
page, Lordship, it starts from 85, Lordship.
This is the impugn order.
Lordship,
And which was challenged earlier? Which was the order which was challenged earlier?
that also I have
What is the page number?
Lordship, that also I have an explanation.
Lord, I'm sorry, my lord, I have another, my lord, read petition. Name is similar, but my lord, the brief is different. Sorry for that.
Name, similar name.
Similar name, my
So Mr.
But-
C, similar name.
district.
Mr. Pang is finding difficult to find out whether you are the same person. Is it, so we'll pass it over some other day then?
What a day, my lord.
Day after tomorrow then? Don't, day after tomorrow?
11.
Because you're going to prepare list today's Wednesday. Then tomorrow is not a motion day. Then it will be Friday. Then next Monday.
14/11.
14/11.
If my learned senior friend, my lord agrees,
Yes.
he may serve another copy because I will have to serve. If he can serve.
See, if you can serve, it will expedite, huh? Otherwise, see,
I'll give.
already thousands of cells.
I'll give him.
Already, yes. Okay.
Item number 5.
Hussein.
May appeal lordship, my lord. This is the in order, my lord, plus 82, my lord. Here this case, my lord, the petitioners 5 deposition was 2 Gaura and 1 is grandfather and uncles are examined, my lord. 1 Gaura, my lord, he also examined. The Gaura was 75 years, and he says, I know the Positive's father from since 1945, and only the discrepancy is, my lord, the shifting, my lord. The petitioner father was residing in Solmari, and subsequently 1985 he was shifted at Kohimari, my lord.
Was he cross-examined?
Gaura, 2 Gauras
Where they cross-examined?
examined, my lord. Base 80
Where they cross-examined?
cross-examined is not able with my.
You don't know whether they were cross-examined or not.
My lord.
You are the petitioner, you should know whether they were
Yes,
cross-examined.
yes, my lord.
They
Base
were-
80, my lord.
Page
80, my lord. And cross also there, my lord.
80.
80, my lord. The Gaura 1 Gaura, my lord.
Okay.
May I read, my lord? Last part, my lord.
Yes.
I am serving as a Gaura Solmari, so last month. I know the father of the Positi Abdul Bari.
Page,
Place, my 80, my lord.
80, yes.
Yes. Last line, my lord. Positi, the Gaura, my lord. Name Abdul Quddus, age 74 years. And I have been serving as a Gaura of village so. Next, my lord, I know the father of the Positi Abdul Malik, who was the resident Solmari as stated above. He was the permanent resident, the said village 1945, my lord. And his name appeared in the voter list since 1965 under 1940 LSC, and he was cast the vote 1970 said LSC. Abdul Barik 3 son, they are namely Hussein, that means petitioner, my lord. And the Positi Idris, his brother, and Sadiq. I do not know anything about their places of residence. They are shifting, my lord. The death with Abdul Barik and want his wife along with his sons residing in the village Chulmari, my lord. The close, my lord. I do not collect having seen the Rostam Ali. This is the grandfather of Positi, my lord. Positi grandfather. Who was the father of the Abdul Barik? Abdul Barik's father's, my lord. And I saw his name in the voter list 1965 and 1965 and 65. Abdul Barik had died about 6 years. Aimon Nessa, his mother of Procedi, her name was not found in the voter list 1965 and 70. I do not have any contact with the family of Abdul Barik. It is not a fact that Abdul Barik is not a father of the Procedi. I do not know as whether his wife Aimon Nessa was a voter or not a voter in the year 1965-1970. It is not a fact that today I depose the under influence of the Procedi, and accordingly I have submitted the certificate is an illegal migrant from Bangladesh who entered 1970. And my lord, the long judgment, my lord, and is my lord S82, my lord. And relevant part, my lord, specific the Gauras. 1 Idris Ali, he was also 70 years old person, neighbor. He also deposed this court. And 1, my lord, Innos Ali, he also Shanti Ranjan Devnath Gaura, he also deposed before this courts. 1 Quddus Ali, he also deposed the honorable courts. And my lord, the discrepancy, my lord, page 91, my lord. On that grounds, my lord. In addition, second, my lord.
Yes.
In addition to above, the proceedings submitted the voter list 2005, 2010, 2014, and 2017, wherein the father of the name is mentioned Abdul Bari. The proceeding has failed to establish that Abdul Bari is appeared in the voter list of 1965, 1970, and Abdul Bari name appeared in the voter list 2005, 2010, 2014. One and same person. On those the voter list, there the discrepancy name associated with the different locality in description. The description. They are, my lord, Sholmari. Their grandfather, father Sholmari, my lord. Thereafter they shifting the Kohimari, my lord. So the petitioner fathers are voter list in Kohimari, Sholmari, my lord. And petitioners and other are related, my lord, Kohimari. And all the my lord, initially in Nos and Gahubura, both sides of Gahubura, one is Sholmari and present residence Kahumari. All are deposed before the honorable courts. The petitioner is the son of Abdul Bari, and she was residing here, my lord, and they also shifting from Sholmari to Kahimari, my lord.
Yes, Mr.
My lord, may kindly see, he has submitted voter list of some 1965 and 70. It's a long gap from 1965, 70 to 2005. There is no voter list as such. Now, second thing, my lord, he has brought, there is no documentary evidence to relating the father and the petitioner. Now, only the evidence here is the matter, the Gaubura certificate and his statement. My lord, the Gaubura in the Supreme Court in the Malad Rupchan Begum case, the Honorable Apex Court has said, like the Malad Panchayat certificates, like the Gaubura certificates, my lord, it can be used by the lady, my lord, woman for the purpose of shifting. It is not allowed for the man, my lord. It is only for the ladies who has no, my lord, direct link documents. They can use this kind of certificates for the purpose of shifting in the NRC.
When this proceeding was initiated against this person, against the petitioner, when the proceeding was initiated?
This is an IMDT case, my lord.
IMDT case. 2010 initiated, my lord. It was noticed was served, my lord.
FT case was registered in 2016, man. This is originally of IMDT case.
In 2016 notice was served, my lord. 9/2/2016. And the Jababandi of land also, land record, my lord, also on the annexure 8. The petitioner name recorded with his father's, my lord.
Yes,
So, my lord, in absence of direct link documents along with the
And
petition.
land document also, my lord.
That is not there. My lord, may kindly see what is observation in page 91 last para, my lord.
yes.
My lord, what my learned friend has laid out from there only. Further, he has not submitted any other relating to name correction of his father in the voter list. Moreover, he failed to bring any such reliable evidence as to why the mother's name did not appear in any voter list or of his brother. No single utterance of words are found, either in the WS or in his evidence regarding nationality status of his brother and his mother, which are much relevant for deciding the citizenship status. During evidence, he has submitted a set date, Exhibit 13, wherein his residential description was released, Puhimari, Moja, Garubat, but nowhere in his pleading or evidence he mentioned that he was resident of that village, said village. In view of the above narrative, my lord, the person my lord, want to bring that is a resident of Puhimari, that has to be pleaded somewhere. Otherwise, how can we accept that document as he is the person of, is the same person? And there is no pleading that he is the same in one person. And my lord, if the father in the petition, my lord, it's different in case of female candidate, female persons, my lord. But in case of male, my lord, he must have some documents along with the father. Because he is a major person. He is not a minor. He is, my lord, 57 years in, my lord, while swearing this affidavit in 2023. If he's 57 years, his name should be there along with father. It's some voter list.
Is not there. Your father's, you along with your father, name is not there.
No, my lord.
Why?
My father was expired, my lord.
Huh?
my-
Expired.
Yes, my lord. His
When?
earliest about 40 years ago, my lord.
That is a vague statement.
No vague,
That
it is
should
written
be
in.
specific. My lord, these kind of statements are vague statement. 40
How
years
can
ago.
vague statement? His father expired
Let
1941.
him give the year at least. I am not asking
Have you
for detail.
mentioned
Yes.
anywhere that your father had died?
Yes, my lord.
Where?
My lord, I mentioned, my lord.
Where is it shown?
I mentioned, my lord, para 4, my lord.
There are 4 or what?
My read petition.
Oh,
case
no
6.
repetition in the record.
Record, my lord.
In the record or in the evidence anywhere.
Yes, my lord. I come. my lord. It is mentioned, my lord. In repetition, my lord. Yes, my lord. Page 53, my lord. In written statement. My father expired 1970. After 1970, my lord. It is 53 page, my lord. And vernacular, my lord. Also, my lord. Is translated for my lord.
After 1970, is it a specific statement? Can it be accepted as a specific statement?
My lord,
His
what
father
kind of
died after 1970. That means his mother may die yesterday also.
No, but then in
No,
the
my lord,
written
I'm
statement
not
it is
saying
mentioned.
that-
Yes, my lord, it was written.
No,
In
it
the
is
written-
written his father died after 1970. My lord, is it a specific? How
And
can
he
I
also
say
expired
his
1982.
father died?
Where
Is
is
it 1970 or 2022 month?
read the vernacular. Annexure
No,
13.
Oh, yes, my lord.
56, para number.
8, my lord. প্রতিপক্ষর
পুনর
দেউতা
আব্দুল
আব্দুল
বারিকর
বারিকর নাম
নামত থাকা হ্যাঁ
কলবর সমর্থ হয়েছিল আৰু ক্রমিক নম্বর 187 ফোন নম্বর 57 আব্দুল বারিক পিতা রুস্তম আলী বুলি 1974 চনৰ ভোটাৰ তালিকাত অন্তৰ্ভুক্ত আছে 70 হিজ ফাদাৰ নেম ইজ ৰেকৰ্ডেড মানে উক্ত ভোটাৰ তালিকাৰ সত্য প্ৰমাণ লিপি আৰু জবাবলত দাখি দিয়া হল মোৰ দেউতা আব্দুল বাৰিক 1970 চনত ঢুকাইছে আৰু
চনৰ
মোৰ
পিছত
মা
ঢুকাইছে।
ঢুকাইছে
Let him read
এক্সপায়াৰ
properly, man.
এণ্ড মোৰ মাক আইমন নাছা 1952 চনত ঢুকাইছে
1992
1992 ঢুকাইছে এই কথাখিনি মোৰ জ্ঞাত আৰু বিশ্বাস।
Like this mother, my lord, he has specifically said that his mother died in 1990.
Some reference
accept-
there will
No, I
examine this
accept it,
one.
my
There's
lord,
some,
My lord, this kind, on the basis of this kind of a statement, because my lord, his
Mm,
father's
ma'am.
name is there in 1970 only. Thereafter, there is no documents.
we'll hear in
He said
detail,
that his
Mr.
father
Pai.
expired it after 1970.
We'll, Mr.
After 1970 can be in 2017 also, 2020 will come.
We'll hear that too.
So at least he should say, my father died in on so and so, in the year so and so. I'm not asking for any date, my lord.
Okay, hard, Miss. Anything? Hard, Mr.
এই স্যার
Counsel for the petitioner, issue notice returnable 4 weeks. Hold for the records. In the interim, if the petitioner has not yet been detained on the strength of the impugned order dated (29, 2022) pass in so and so, page 82. He may be allowed to remain on bail subject to appearance before the SP border, Nagaon, and furnishing a bond rupees 5,000 with surety of like amount to the satisfaction of the SP border. Baki all condition, biometrics, fingerprints, then mobile number to be given before leaving. Inform the SP border the particulars of the place of destination.
Hello.
Item number 6.
You must provide mobile numbers properly. Mobile, you must provide the mobile numbers. You have mobile number? No, you have mobile number. Provide mobile numbers, contactable. Failure to provide proper mobile numbers, etc. information will warrant recalling of the order of bail. You did write this in earlier case. Next.
May please, your lordship. My lord, in this case, my lord, admittedly, my lord, the record says that the family came from East Pakistan, my lord. My lord, the name of certificate of registration annexer 3, my lord, lordship, page 27, where my father's name, my
27,
my lord, father's name, Pratap Chandra Nath. These documents has been discarded, my lord, saying that the case record referred by the border police, where father's name is recorded as Pratap Roy, not Pratap Chandra Nath. On that ground, my lord, these documents has been discarded, my lord. My lord, can it be, my lord, the police report can be an evidence, my lord?
Okay, then yes, Mr. We have to, perhaps we require, yes, Mr. Rico,
Yes.
take the line account. No, 4 weeks notice LCR in the meantime.
My lord,
SP border?
SP border, not Kachar, my lord.
Item number 7.
My lord, here also, my lord, the father's voter list of 1966 has been furnished, my lord, annexer 3, page 34. Then, my lord, 1970 voter list, annexer 4. Then, my lord, voter list of 1997 of his own. There was some land documents also establishing linkage, annexer 11.
Father's name?
Father's name is Qasimuddin. 6670 voter list contains the parent's name. His name is at
6670. Then after that,
My
Next,
lord, 97 brutal list of the name of the petitioner and his brother, my lord. Then, my lord, one land documents, my lord.
who is your father?
My lord, Kosimuddin, my lord.
When did he die?
My lord, life died long back, my lord.
Long back means which year?
My lord, lordship may kindly have a land documents, my lord. Establishing
Oh.
linkage, establish linkage with parents, my lord. Annex R 11, page 46.
Yes.
Page 46, my lord. The vernacular is at next page, my lord.
Kosimuddin Mondol,
Yes, my lord. Somewhere,
Moina Mondol,
my lord.
Miadi Jamabandi, Tolabila. But that's a Bizni
My
Mauza.
lord, there is shifting, my lord, that has been pleaded.
But-
Case, my lord.
Oh, Jamabandi, which year?
My lord, Jamamandi, my lord, it is of 2000. My lord, 2018, my lord.
2018
So, my lord,
Jamabandi.
it is not, certificate copy has been obtained on,
Which day? When did you purchase the?
my lord. Purchased, my lord, 1992.
98.
98, my lord.
So when did your father die?
My lord. After death, my lord, the this mutation was done, my lord.
So mutation in whose name?
My lord, the proceedings name and his brother also. Lordship will find in page 46 in remarks column as per order dated 12/6/98 passed by the circle officer, the names of Anar Hussain, the proceeded, his brother Muhammad Abul Hussain, both sons of Kosimuddin, are mutated in Patta in place of Pattadar number 2 in the respect of 1 bigger 3 kata 15 lakhs as legal heads. So these documents is enough to establish linkage with parent.
Jamabandi.
My lord.
This is Jamabandi showing your mutation
Mutation
in your name.
in your name along with my brother. My lord, here circle officer, deputed person of his staff to examine, my lord. Then, my lord, the ration card was also approved by examining.
Circle
The-
officer, what did the circle officer say?
Circle officers, my lord, DW2, which you will find at page 52.
What does he say?
My lord, name Sri Subhas Medi. I have authorized by the circle officer of Manipur Revenue Circles to adduce evidence and produce documents in connection of this case. Exhibit 1 was issued by the then circle officer of Bijni Revenue Circle. The issuing circle officer's name was Gaya Prasad Agarwal. Exhibit 1 is his signature, which I know. The land of Exhibit 1 is originally in the name of Kosimuddin, son of Moina Mandal, but Patta number so-and-so, Dag number so-and-so, measuring 3 bigha 4 kata 13 lesson. As per order of circle officer dated 12/6/98, this land mutated to part of that land measuring 1 bigha 3 kata 15 lesson in the name of Muhammad Anar Hussain and Abdul Hussain in the capacity of inheritance. Exhibit 1 2 is the original Jamabandi. Exhibit 1-3 is the Sita. Exhibit 1-4 is the part of the trace map of 12 number village.
Cross partition.
Cross.
My lord, cross. No document available today on the basis of which this land has been mutated as inheritance. I cannot say whether other brothers and sisters filed their NOC in this connection or including any death certificate. In the year 1987, the land exhibit mutated to Patta land from annual Kiras Patta. It is not the fact that the mutation was done following the proper procedure. Well,
It is not a fact that the mutation was done following. What is the meaning?
following proper procedure.
What is the meaning?
My lord, he wants to say that there some procedural lapse in the mutation, my lord, that may, but first part has clearly established the linkage, whether by disputing this way, my lord, the linkage can be denied. And the brother was also mutated in the mutation order, disclose the brother's name also. So this version, my lord, is not correct. I cannot say whether other brothers and sisters filed their NOC in the country. Brother himself was the beneficiary of the mutation order.
And what is this annexure 15?
Annexure 15, my lord, the evidence of my lord, he is the staff under the my lord, he is the Inspector of Food and Civil Supplies, Bongaigaon. I shall state truth and only truth. I have appeared in this tribunal on receiving the summon. I am presently serving as Inspector of Food and Civil Supplies, Bongaigaon. Exhibit J is the family ration card issued by the Inspector of Food and Civil Supplies, Bongaigaon, in favor of Sajda Begum, wife of Anar Hussain. Exhibit J1 is the beneficiary list prepared by the Gaon Panchayat. On the basis of 2011 census, Gaon Panchayat are empowered for selection of beneficiary. A selection list prepared by the Panchayat level, headed by the BDO, and the said list sent to the Deputy Commissioner for approval. Therefore, approved said list by the Deputy Commissioner, subsequently sent to the department, then applicants file of data in C form, along with the required documents entered in our computer portal and issued the ration card in favor of the beneficiary. Exhibit J2 is the computerized online RC page. Exhibit J3 is the departmental computerized selection list beneficiaries. The ration card is in the name of Sajda Begum. I have not
Your
his wife, my lord. His
Okay.
wife, my lord. So it's, my lord, it's also valid documents, my lord, that there is nothing adverse to the claim, my lord. It's valid document,
your parents are in Bizni
my lord.
and you are in
My lord, this certificate, my lord, this,
you are staying where?
my lord, now, my lord, under Bongaigaon district, my lord.
Have you mentioned anywhere that you are shifting from Bizni to
Yes, my lord.
where have you mentioned?
Shifting to what, sir? W, sir. My lord, the para 4 shows that their forefathers are staying in Ismail Manburi, PS Bagbor. Then para 5, my lord, family members shifted to village Salavila around the year 1979 due to river erosion and permanently settling in village Salavila. Salavila is, my lord, in under Bongaigaon district. Neighboring area, although district is different, my lord.
Okay. We are not saying that, but then the fact that his name is recorded and circle officer has been examined.
But it is not the circle officer.
Sorry, Mondal.
authorized.
Mondal did not say that it is not valid or something like that. He says,
But he did not bring any records.
who is this CW, C2? Whose witness is this?
My lord,
It is
Well,
called by
see,
the my lord,
is my lord
it is initiated by the
Inspector of
petitioner.
Food and Civil Supplies, my lord.
That is has no value because it is, he has said that he has issued that, my lord, that list was prepared only in 2011 on
No,
the
no.
basis of 2011.
No, this CW1,
PW1 is the proceeding himself, my lord.
no, this who are that who mentioned about the
Land documents.
land document?
My lord,
Yeah.
my lord, that is, my lord,
Page.
that is, my lord,
Page
page
52.
52, my lord.
So this Subhash Medhi,
Subhash Medhi.
who
He is the,
witnesses?
he is the staff under circle officer.
It is DW2,
Manipur
my lord.
Revenue
It is
Huh?
the defense witness, their witness.
The witness. But he has not said anything contrary to what the document.
My lord may kindly see what I'm saying, my lord.
Yeah.
We have to think, we have to see the entire matter, my lord, from 1971
Correct.
and my lord, prior to 71 and after 71. My lord, he has documents of 1966 and 71 further, but thereafter there is no documents at all. Now suddenly he, my lord, as per this report, the father acquired the land in 1987. My lord, that
But
was
when he was born in 76.
My lord,
no,
my lord,
his
I
father,
have,
my lord.
I
He
have,
was
annexed-
born in 76.
I have annexed the voter list of 97, 2000,
76 is after 71.
my lord.
So
No, I am not, my lord. If the father is there, my lord, in 1976, your lordship may kindly see two things, my lord.
when your
Six-
father died,
My
That is
lord,
not specified.
when did your father die? When your father died?
my lord, that has not been, my lord, specifically
That's why,
stated,
my lord. These
You
things
you
have to
don't
be-
mention anything about your father.
my lord.
My lord, in all cases, your lordship will find two.
89, the father of the expired around year 1989.
My lord.
96. So in before 19 at the 70, there should be some voter list.
After
My lord.
70, before
My lord,
90.
some
We'll
voter-
examine. Okay, hard Mr. Sigdalana Council issue notice for which call for the records. The interim period will be considered on receipt of the records. LCR. Yes, next.
Item number 8.
my lord, interim maybe, my lord.
We'll consider after receipt of the LCR. We'll examine. Next.
Item number 8.
Yes.
Please, your lordship, my lord. In this case, my lord, the brother of the, my lord, petitioner deposed as DW2, my lord. And the petitioner also, my lord,
Huh?
submitted
Who's brother?
brother, my lord, DW2.
Brother. Who
my
is his?
lord.
Yes. So his deposition page.
Deposition kindly see page 41, my lord.
Page 41. Shah Jalal.
Shah Jalal, my lord. That my name of my father, mother, and my respective address are written above. Firoza Khatun is my elder sister. My father had been a regular voter of.
So
some-
brother has come, Mr. Examine, because
Hello.
in the cross examination he said is not a fact. Is not a fact. Huh? Let us examine if the brother has come. Okay. Hard Mr.
Here,
Notice 4 weeks. Records. Interim.
oblige.
Item number 9.
Yes, Mr.
My lord, here, my lord, the impugned order at page 85,
Page
85.
55.
85.
My lord,
85. Yes. Yes, tell us what is the
My
problem.
lord.
Yes.
Here, my lord, the parents, my grandfather is voter in 1966. Lordship will find at page 34.
Grandfather.
Yes, my lord.
Mofida
Father.
Khatun.
Yes, my lord.
Anybody who came to depose in your favor?
My lord, my lord, proceeding as gives evidence, then my lord,
Who else?
my lord, at page 63,
Who is he?
my lord, the proceeding himself. Then my lord, her mother at page 68.
68.
Yes, my lord, DW2.
Mother.
Mother.
Yes, sir. 68.
Her
68 is the
our cross-examination part
page.
at page 77.
77.
My lord.
Cross examination.
I am residing at Lempara. My husband died 10 years back. My husband's name is Hanikuddin. My husband's house is at
Yes, Mr. Pine.
My lord, the petitioner's claim is that her father is Hanipur himself. My lord, now, my lord, there is no document as such from Hanibuddin prior to 1970.
Prior to 1970,
So cut off, he has to link somehow. to
19, before 1970, your father may be Hanifuddin, but is Hanifuddin
My lord,
existence?
my grandfather's is voter in 66.
Let us see that. Page,
Then, my lord, 70 also at
Page,
page 34.
34.
Then, my lord, 70 at page 36. Vernacular is also along with the translated copy. In 1979, my father is voter with my grandfather. My lord.
Where is it? Page,
Page 38. My lord.
page 38.
My lord, Hanifali.
Hanif Ali. is it?
Yes, my lord. My mother is also voter in 1985.
Confusing. My husband, huh?
Then, my lord, in 1997, my father, my mother
This
is 42, my lord.
These were not before the tribunal, man.
Huh? Sorry?
These documents were not before the tribunal.
My lord, how he can say, my lord, exhibit? This is exhibit, these are exhibited, my lord.
Which one? Which
Lordship will
document?
find in the page 42, the next page, vernacular 43.
He exhibited, my lord, exhibit A is 66 voter list, exhibit B is 70 voter list, exhibit C is original marriage certificate, exhibit D is original copy of the electoral photo identity.
My lord, exhibit marks are there, my lord.
Passbook.
Signature of the member is also there in page 43, my lord. How he can say, my lord?
No, this is in the judgment, it's opinion itself, in page 87, my lord.
My lord.
What were exhibited, it is there.
So the exhibit this number C,
Yes, my lord.
Original copy of the marriage certificate. Number
FT4 Gwalpara is signed. Yeah.
So what is there in the, my lord, the record is not with me. Record has not come. My lord, it is.
So we'll
from
call for the record.
Page 87 only, my lord, your lordship may kindly see it is in the order, opinion, it is recorded, my lord. On the basis of opinion, I'm. Opinion, my lord. Page 87, my lord, para 5, my lord. What were exhibited, it is clearly indicated.
13, 10, 16.
66, 70 were, my lord, exhibited. Copy of
My lord,
marriage certificate was
exhibit,
exhibited as
my lord,
exhibit 6.
exhibit march is there, my lord, where my mother, my father are voter.
Anyway, we will call for the record now.
Let the records become, my lord.
My lord, I will protect my intent.
Opinion is 2020, fine.
But they have-
2020.
Yes, they have
2020.
come late, my lord. In fact,
My lord,
it is their duty to, they have
maybe
to come in earlier.
because of
Oh,
law,
but
my
then-
lord,
Brother, when the tribunal passed the order on December 2020, you have been alerted. The government has been alerted.
My
You
lord,
cannot say that they did not appear before us.
my lord, it is hide and seek game.
No, that you
It's,
can't.
my lord, had they have been, my lord, original citizen, they would come in the early stage itself.
Our Mr. Lara counsel for the petition, he should know 4 weeks interim. Call for the records. Is SP border?
my lord, SP border Gwalparam.
My lord, in fact, he has submitted this document in WS, a Xerox copy, but these were not exhibited. It is there in 87. Why they did not exhibit it? They should brought into the record for exhibition and for cross-examination.
Exhibited, my lord, exhibit marks are there, my lord.
But in the evidence, it is mentioned. Brother. In the evidence, it is mentioned that exhibit.
Evidence of, my lord, DW1.
Yes. Develop like that.
Yes, next.
Item number 10.
May I please close? My lord, petitioner is my lord declarative honor of post 1971 stream, my lord. He relied on voter list of my lord 1966 and 70, wherein his father's name is my lord recorded, my lord. The one thing is that, my lord, in notice, my lord, his father's name is my lord shown as Ilahi Boxo, my lord. But however, my lord, in written statement, his father's name is declared, my lord, is Insaf Ali, my lord. So accordingly, he submitted the documents. On the basis of this point, my lord, his entire documents are, my lord, rejected, my lord. So that is the yes, my lord. Your lordship
And
can
we have to examine it. Okay, notice record interim.
In that earlier case, my lord,
bail, my lord, protected.
Huh?
Maybe protected, my lord.
SP border?
Bongaigaon, my lord.
Wow.
In the earlier case, my
Sorry?
in the earlier case, in written evidence, they have mentioned it, but that has to. It is written in the written exhibition, they have written evidence, they have said that this is exhibited, but in the tribunal, they have to exhibit it by my lord in the proper form.
Let us see, because written evidence is also a form of a tendering evidence.
My lord, in the written
CPC
evidence,
allows
they
it.
submit the Xerox copy.
Okay, we'll see that. We will examine that. We will examine that. Yes, next.
Item number 11.
File your blessing. May it please, the lordship.
Yes.
My lord, the opinion of the learned member is at page 90, annexure 2. And
Yes.
so in my case, my elder brother has deposed, and it is in page number 60, annexure G. Your lordship,
This
allow
60.
60.
60. What is your elder brother's name?
Abdul Rahman.
Abdul Rahman. My sister, cross, my mother's, she died. I do not know if she have got married. I have passed BA. Asya Khan got married to Noor Bijan Khan. Total 7 sons, 1 daughter. Their names are. Oh. He appears to know the children very well. Okay, we'll examine that.
He knows by lot. Only thing is that anybody can come sit it, but
Anyway,
there must be, our contention is that there must be some documents, my lord, to link each another. Else anybody.
We'll examine it. Yes, notice. Which district?
Lordship, at page number,
SP border?
district Morigao.
Huh?
Morigao.
Notice record interim SP Morigao.
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 What is your name?
My name is S. Zaman.
Mr.
S. Zaman.
S. Jamal. Huh?
Lordship,
Yes.
most humbly interim.
Item number 12.
Deeply obliged.
May it please the lordship, my lord, here in this case, my lord, the proceeding after receiving notice, she appeared to file WS evidence in she was submitted, but she was not cross-examined. And for want of cross-examination, everything is discarded.
Why
and-
she was not cross-examined?
My lord,
Why
My
she
lord,
was not
my lord,
cross-examined?
there was some problem from the tribunal also. The case was transferred. Then, my lord, some dates proceeding went to the tribunal for cross-examination, but could not taken up because of some problems on the part of the tribunal member, my lord, because she member was not present on some dates. My lord, there was, my lord, this type of problem, my lord, the cross-examination failed. On some dates, she was also absent, but advocate taken steps, my lord. So, my lord, lordship may kindly have a look at paragraph 11 of the judgment, page 56. Only for want of cross-examination.
Moinal Haq.
My lord. Judgment, my lord, starts from page 53. My lord, I am relying on paragraph 11, my lord, of this judgment. The OP, after contesting the case by filing written statement and evidence in chief, neither OP subjected him to cross-examination to nor prove the facts in issue of the adducing present reliable and admissible evidence. Mere filing of the written statement and evidence on affidavit in accordance in a proceeding under the Foreigners Act would not be enough it would be proved by the OP. So, my lord, petitioner may be given an opportunity to face the cross-examination. He has the documents, my lord. Everything is there, my lord, only because of some problem, my lord. My lord, the notice was issued by tribunal number
6 and the judgment was passed by the tribunal 4. So transfer of the case record is also problem. And in some dates, admittedly, the proceeding are not appeared because of some of our personal problem like ailment, my lord. And step was taken by the lawyers. So, my lord,
Yeah, okay.
My lord, may kindly see this, not only that, my lord, he neglected the, my lord, entire case in the tribunal. The opinion was passed in 2019. He is approaching after 3 years. Before this honorable court. He has given some explanation. So conduct is, my lord.
What is the explanation he has given?
my
Yes,
lord,
given, my lord, he
My lord,
could not
so
collect
far
the
the-
certified copies as the engaged lawyer did not, but my lord,
my lord,
did not cooperate.
19. My lord, financial problem is also one aspect, my lord.
My lord,
Once
the entire act, purpose of this
He-
act, it's that
he
would
went
say
to
it will
Bangalore
be
for
completed within 2
engaging,
we could not complete it for whatever reason, my lord, it could not be completed within 2 months. But it cannot be so long, my lord, continue for long years, my lord. These are the cases initiated from in 1997. For my lord, huge numbers of cases. These cases were sent to the tribunal in 2016-17. And they used to take time, my lord, not only one day, my lord.
Correct.
my lord,
You-
he is voter with his parents, man.
And they certified.
And also, my lord,
in 2020, my lord.
Paragraph,
Correct. Only thing is that yes, correct, that he has come late, 2019.
my
But
lord,
at the same time, the state also has not taken anything, any step also. Had he been detained, perhaps, yes, we
No,
may
but-
say that we will refuse to grant bail or whatever like
My
that.
lord,
But now,
In
they
fact,
also have not, they also came late, you have
I'm
also
not on
not
that,
done
my lord.
anything.
I'm not on
my
that.
lord,
No,
If your
that is
lordship-
the, because we are only in this, interim, only what to do in the interim. That is the only concern. Okay, then we'll issue notice record interim.
deep love like that.
Item number 13.
My please, Lordship. Lordship, in this case, opinion at page 76, Lordship. In this case, the parents' name appeared in the voter list of 1966, 70, 89, Lordship, onwards, Lordship. The brother's name appeared along with his father in the year 1997, Lordship. And this brother was examined as DW2, Lordship.
Peace.
Page 73, Lordship, close part of the DW2, Lordship. Page 73, Lordship.
Anwara is my younger sister.
Yes, Lordship. Moreover, Lordship.
Or this is the close part.
Yes, Lordship.
Huh?
Yes,
My sister, my father died 8 years. I don't remember when my mother, but she died from my father cousin, but I don't know his age. 60 past my board, my father, I caused my friends. My sister, when I have 6 brothers, I know he got married. I know my father's name. My sister is not else with me. Got married.
she
Yes,
also
sir,
examined
Mr. Brother has appeared. Let us examine them, Mr. Pine. Huh? Okay. Notice record interim. 4 weeks, huh? Issue notice within 4 weeks. Call for the records in the interim. If need event, if it has not been detained on the stand of the impugn order dated Spencer passing FT case number Spencer may be allowed to remain on bail subject to appearance before the SP border.
Moigaon, Lordship.
Morigaon.
Moigaon.
Huh?
Bongaigaon.
Moigaon.
Bongaigaon. In connection with Spencer case. Biometrics, fingerprints, mobile phone to be furnished to the concerned SP board.
Item number 14.
May I please your lordships. Lordship, the petitioner before you is a lady who was born and brought up in the district of Lakhimpur. Lordship, she was later on married to Sonitpur, and their lordship, the SP Sonitpur registered a case against her in the year 1998, and subsequently the Honorable Tribunal Sonitpur passed an order in 18/5/2022. And lordship, we are before here, lordship, challenging that order. Lordship, the main grievance is this, lordship, that while submitting all the documents,
they were not properly appreciated. Lordship, we relied on voter list of 1966 from both paternal and maternal side. Lordship, at page number
Yes, yes.
41, the page number 41, Lordship, is the voter list of 1966 of the father of the petitioner, Ranjit Kumar, who casted his vote. And page 43 is the NRC legacy data, where also the name of the father of the petitioner is there, Ranjit Kumar, and voter year is 1966. Lordship, similarly, Lordship, from the mother of the petitioners, from the grandfather of the petitioner, Ashananda De, his voter list has also been annexed, Lordship. Page number 47, 1966 voter list.
Yes.
And Lordship, subsequently, legacy data of Ashananda De,
This
that
is
is
this
the maternal
participant whose name is there?
maternal grandfather, maternal grandfather, both side.
Okay.
Paternal grandfather and maternal grandfather.
Ranjit Kumar Krishna. Okay. Yes. Then
Lordship, but in the impugn order of 18/5/2022, this were not appreciated properly, Lordship. In fact, the grievance was this, that we had categorically stated that we migrated from Bengal, but it was written as Bangladesh, Dhaka, Bangladesh, and hence, Lordship, the order was.
examine Mr. Pai. Okay. Notice record interim. Which district?
Sonitpur, Lordship.
SP Bodasoni.
Obliged, your Lordship.
Item number 15.
May I please, your lordship, my lord.
Yes.
My lord, in this case, my lord, the petitioner, my lord, exhibited number of documents, my lord, but the learned tribunal, my lord, he has held that the petitioner's name, since her name was not unlisted in any document with her parents, therefore she has been declared to be a foreigner. Lordship will kindly have a
Will
look
was examined.
the concerned Gabura of paternal village of the petitioner, my lord.
Will shows that statement.
Page number, my lord, 50. Lordship will kindly have a look. That's 60, my lord, annexure 8, my lord. The position of Gaubra. He's a man of 67 years, my lord. My lord, the petitioner's name would have been reflected in the, my lord, the concerned Jamabandi Koi, my lord, because her father, my lord, died, my lord, just
Where
5
is
months back.
Jamabandi? Where is Jamabandi?
Jamabandi is at page, my lord, 39, my lord, is the type copy man, and page 40 is the vernacular, my lord. Her father's name, my lord, appears at serial number 11, my lord, in the left side. Asarat Hussain.
Asar Hussain.
Yes, my lord. Sir.
Pita
Pita Hassan.
Hussain Ali.
Yes, that is there, my lord. Asarat is the father of the petitioner, my lord. Somewhere that has wrongly.
Asaraf.
Asarat, somewhere, my lord. Tasarat, my lord. Spelling mistake is there, my lord.
Asarat Hussain.
Asarat Hussain. And she had, my lord, rightly deposed.
Rajia Khatun, the Asar Hussain is your father.
Father, my lord. And in her deposition, my lord, she had, my lord, during cross-examination, she stated that her father had died, my lord, 5 months back, my lord. Just 5 months back, my lord. That is why, my lord, probably, my lord, her name was not reflected in the Jamabandi Koi, my lord. She could not inherit the land, my lord. Probably, my lord. Now she will kindly have a look, page 53, my lord. the cross part of the proceeding, my lord.
She
Connectors.
married in the same village.
Same
Lochenbari.
village, my lord. No
Lochenbari.
shifting, nothing, no, my lord. Yes, she also got married in the same village, my lord.
Yes, Mr. Then let us examine same village.
Only my lord, the problem is the link, my lord, between the petitioner and the father, my lord. Because
Correct.
the Jamabondi doesn't provide anything that she has some link with the father.
Of course, that is true in the sense that,
And the-
but then he said that this Jamabandi was produced
Yes,
and
This
he
was-
said that this Asarat Ali Hussain, he is the father,
yes.
That is,
daughter of late Asarat
my lord,
Hussain.
she has produced the certificate, but nowhere it is in the Jamabondi reflect that her name is not there in the Jamabondi. That's
Not correct.
what I want.
Women,
the-
being a woman may not be
Second-
there also.
Yes,
Second,
my lord,
my lord,
the other reason is there, my lord, because her father died, my lord, 5 months back, my lord. Just 5 months.
Mhm.
That is
only
why
thing
also.
is that the Gaubra certificate. Gaubra has said he has not issued on the basis of any record. That is the problem.
But then Gambara appears to know his father also.
Yes,
her
everyone
father
will
also. That's
Father,
why.
my lord. The other parts, my lord, we have to see entire record, my lord. He
And
knows
we'll go
father,
for the
doesn't
record.
know the mother.
Huh?
If he knows the family, my lord, he should know each and everyone. Otherwise, how can he issue my lord, certificate on personal knowledge? If it is on the record, there is no problem.
Mr. Pang, what kind of documents are maintained by Gamburas?
My lord, if Gauras, they must have the voter list of my lord both the SS, if they issue, and they must have record, my lord, own record,
What are the functions of Gamburas under
and my lord,
did not maintain anything?
yes, he doesn't maintain anything, my lord. But that's why, in fact, my lord, our contention is that he cannot issue certificate, this kind of certificate.
But he can
I know.
depose.
He
that
can
He
he
can
is the-
depose on
he-
personal basis.
He can depose personally.
Very personal.
Yes.
My lord, only my lord thing is that if he depose on personal knowledge, that has to be seen personally, my lord, as a oral evidence, not on the basis, not the as a certificate issued, my lord, as a documentary evidence.
Record interim.
SP border Moriga, my lord. My lord. High level.
Item number 16.
My lord, order copy is not legible, my lord. Here.
My lord,
It is only a copy.
this is
Give a
the,
copy or legible one. You can argue on the,
Could not able to read.
after a week, next
My-
week, Monday.
my lord, this is second round litigation, my lord. Second round is earlier.
Give at least the basic thing requirement is to give a copy, a legible copy. That is how.
My lord, I will
legible-
submit on the record, my lord, and documents, my lord, which are exhibited before the tribunal. My
Oh,
lord.
he says he's not legible. You provide a legible one. That is what he says. You know, under
I will-
Preventive
later-
Detention
later,
Act,
I will
under the
furnish a petition.
Preventive Detention Act,
Judgment copy, I will furnish, my
under
lord.
the Preventive Detention Act, if a detainee is furnished with an illegible document and the order is quashed by the court, High Court. Because what is the idea? Because he has been prevented from giving a proper representation because he cannot read. If you give, the law of detention is such, why it is important?
I think my lord.
Therefore,
will agree,
the
my lord.
idea is that
outside
he
my
must
lord,
be, the other side must know what is being written. If you provide him the document which is unknown to him or written in a foreign language, the ground for quashing the set aside. The reason is that he must be given the opportunity to know what is that. The learned counsel say, I can't read
my lord,
because
I
you
will-
have
I will
given an
furnish a fresh
illegible.
copy, my lord, later
So
on.
face copy,
Lordship
yes,
may-
we'll hear it
Lordship may hear, my lord.
next week.
14,
Day
11.
after tomorrow, my lord. Today I will find it. Day
Monday,
after
14,
tomorrow.
11. Item number
You have to be
17.
careful when furnishing copies to the other side. You cannot just give a copy which is not
Day
legible.
after tomorrow, some urgent is there.
Monday.
Monday, my lord.
Item number 17.
Here in this case, my lord, parents is, father is voter in 1966, 70, then my lord, 85 also, 85 onwards. Father was examined, my lord.
Father examined.
Yes, my lord.
Yes,
As
sir.
DW2, annex
Yes, Mr. Sharma, father
66.
examine, we'll examine then, huh? Okay,
It is real father, I don't know.
sorry,
It is real father, Lordship.
we'll see that, we'll see that. Okay, notice record interim.
My lord, SP Masalpur, my lord, Baksa.
Item number 18.
Deep Lord. May I take your lordship? Lordship, the petitioner was declared to be a foreigner because as per the opinion, she could not prove the link with the father. However, there were 3 documents, your lordship. Page 51, the voters list of 2011, where
Mhm.
her name appears to be the daughter of the father Safuruddin Mandal.
Let us see page
Page 55, page 51.
51.
Page 51, it is a voters list. It was
Of?
exhibited as Exhibit F.
Laila Bibi,
Laila Bibi is the petitioner. Father's name is
Pita
reflected.
Safaruddin Mandal, in 2011.
2011.
Yes, any other document?
Thereafter, the voter ID card is at page 55.
No, before that,
Before that, your lordship, there is one Jamabandi as well, your lordship.
where is the Jamabandi?
Jamabandi is at page 58. Page 59, I'm sorry, your lordship, it is in SMS, your lordship, page 59. The remarks, the second remarks, she along with her brothers and sisters has inherited the land of the father. Safuruddin.
You forgot to transfer or what?
Your lordship, the first page translation is given in the
Yes,
second page.
page 57.
57 is the translated copy, 59 is the SMS copy.
Laila Bibi.
Laila.
Where is the name Laila Bibi?
13, your lordship, at page 58.
Laila Bibi,
And the explanation is given in page 59, your lordship.
page 59. What is the explanation?
The second paragraph. চিঠার চক্রবিষয়ের মহোদয়ৰ চৌৰাংশ তাৰিখৰ হুকুম মৰ্মে উত্তৰাধিকাৰী দফৰ সূত্ৰে ইমান নম্বৰ পট্টাৰ ইমান নম্বৰ দাগৰ মৃত পট্টাদাৰ চফুৰুদ্দিন মণ্ডলৰ স্থলত 13 নম্বৰ লাইলা বিবি, 14 নম্বৰ হাৱা, 15 নম্বৰ নিচৰণ নেচা, 16 নম্বৰ দেৰ গ্ৰেজুৱেশ্যন চেণ্টাৰ নামত নামজাৰি নথিভুক্ত কৰা হ'ল।
Then invitation. Yes, Mr. Sharma, we'll examine then that case. Somehow the link may be very tenuous, nevertheless a link. Okay, notice record interim.
Item number 19.
My lord,
Yes,
Although the order is ex parte lordship, my lord, she could not appear, my lord, due to my
Why?
lord close motion.
Huh?
My lord, woman lordship, many problem might have been there, lordship, but as per information, my lord, some problem was there, my lord. Lord
Item
motion
number?
lordship. 19 lordship.
19.
My lord, now kindly be seen, my lord, page 25, on the basis of which, my lord, she was declared, my lord, foreigner. My lord, as per verification report, lordship, submitted by the officer, inquiry verification officer's lordship report. That
Who is
a
this migration certificate?
Migration, father's migration, lordship.
Okay.
Now,
So
my
you
lord,
cannot appear.
yes,
You cannot appear. You
appeared,
cannot
my
file
lord.
the written statement also.
Yes, lordship. Subsequently, my lord, some irregularities were also there, that is admitted, lordship. Now, on the last date, my lord, that is the problem, my lord, she could not appear, lordship. And,
But you had filed the migration certificate. Yes, Mr. Sharma, then they
Written WS has been annexed. Lordship.
will call for the record.
Yes.
Notice record interim.
unlike lordship.
Item number 20.
Well, the petitioner's grandfather's name appeared in the voter list 1966 matter. There is not 12 matter.
Yes. What is the name?
Go. Name
Rashid.
is Rashid Miller.
Then,
And father's name Miller, page number 18 Miller.
then, yes.
Then her uncle Miller was examined. Uncle was examined Miller, page number 57.
What is the name of the uncle?
Name of the uncle Miller is Miller Nur Jamal.
What is his name?
Miller, page number 57 Miller.
His name in the list.
Page number 57 Miller. First paragraph, he
Please.
has stated. Page number 57, first paragraph, he has stated that he is the uncle, my lord, of the
Nur Jaman,
my lord,
son of late Abdul Rashid.
my lord.
But that any bottle is showing that Nur Jaman is the son of Abdul Rashid. Where is it?
Voter list of the father, grandfather, I have annexed, my lord.
But what about with his your father name also there in the voter list?
Yes, my lord. My
But
father,
your uncle is not there. Why?
my lord, that is page
Uncle is your father's brother or somebody else? This uncle has come from where?
my lord,
Huh?
page number 18 may be seen, Nur Jaman is there.
Page number?
18, 1-8.
Nur Jaman is female.
That is
Huh? What is the original?
male, my lord.
Male. Nur Jaman, Pita. Okay. Nur Jaman is the son of Rashid.
Rashid.
Okay. We will examine them. Okay, notice record in
Item number 21.
May I please, your lordship? My lord, in this case, my lord, the petitioner has been declared as a foreigner without evidences being adduced by her, my lord. Because, my lord, when the case started, my lord, the case started from January 2020 onwards, my lord. Then, my lord, on 5th of March 2020, she submitted her written statement. Then, my lord, subsequently, due to the COVID restrictions, the functions of the tribunal were suspended, my lord. When the COVID restrictions were lifted, the tribunal's functions resumed, my lord. The lawyer of the petitioner did not inform her that the case has now resumed and you need to come and adduce evidences. Then, my lord, after she remained absent for a few days, the petitioner was declared as a foreigner, my lord. Now, my
Then
lord,
what to do, Mr.?
my lord, matter may kindly be remanded back.
Let the record come, Lord, after verifying, Lord.
Okay, see the record, notice record interim.
Item number 22.
My please, your lordship. In this case, my lord, the petitioner here, my lord, exhibited two vital documents to establish his linkage with his father. The first one is in page 71, school certificate.
Yes, please.
Page 71, my lord.
Hmm.
School certificate issued on 2010, my lord.
Hmm.
He was studied up to in the Fatehpur Primary MA School. He studied there.
Somebody came to
Yes, my
prove
lord.
this.
Yes, Miss Page, my lord, page 73,
Who is he?
headmaster of the said school.
Came.
Yes, came, my lord, because my lord, the headmaster, author of the document who issued the said document, he was expired. The existing headmaster, he came before the court and examined his DW2, my lord. Page 70, he was cross-examined by the tribunal. Page 73, my lord.
What do you mean examine this record?
SP Lokhapur, my lord, SP from Lokhapur.
Item number 23.
Oblige, my lord.
My lord, in this case, father and mother are declared Indian, my lord. Lordship may kindly come to page number 37 and 41. There are two judgments, my lord. Proceeding was taken place, my lord, against the father and mother, and both are declared Indian, my lord.
Did you mention that your
Yes, exhibited, my lord.
exhibited?
My lord.
Then what did the learned tribunal say?
Say something, my lord, some type mistake or like that, my lord. Link, sufficient link document also available, my lord. Grandfather's name 1966, page number 13.
No, is there any difference in the description of your parents in those FT cases? In those two cases where your father and mother were declared Indian,
My lord. Father and mother appeared. Though father and mother were also suspected and notice was issued, my lord. They appeared and documents submitted, my lord, examined
and they were declared Indian.
Indian, my lord. I have annexed, my lord.
And you have been separately proceeded.
Separately now, my lord.
Your is Maqbul Hussain.
Maqbul Hussain, father, my lord.
You are Mohirul
My
Islam.
lord. Somewhere Mohirul and somewhere Mohiruddin. That is the problem, my lord. Otherwise, my lord, the father,
They depose also before the tribunal. They came to depose in your favor before
no,
the tribunal.
father is no more, but my uncle came, my lord.
We'll examine then what, yes, notice record. Entry.
Item number 24.
In this case, my lord, her uncle was also examined, my lord. There's no 40, my lord.
Uncle was examined.
My lord.
Page
40.
40.
My lord.
Cross examination, page.
Cross examination, I could not obtain the certificate. Record may be called for my, I could not annex my lord because for only judgment was furnished to us, my lord. I applied.
What is the name of your uncle?
Nur
Nur
Hussain.
Hussain.
my lord.
In his cross examination, you say OP is second daughter. He has 8 son daughter, but okay. He denied he is not on. Okay, we'll call for the record. Notice record interim.
Obliged.
Only in 1966 and 1971 document lordship voter list.
Sorry.
Voter list of 1966 and 1970. The name of Nur Hussain was existed lordship.
Okay,
In
we'll
other documents, there is no name. Although he is alive till that lordship. No voter list.
next.
Item number 25.
Yes.
Lordship, here we have select the Indian opinion lordship page 104 lordship. I have been declared as a foreigner lordship.
So what is wrong with that?
Lordship, my father has also deposed in this case, your lordship.
Father
as a-
came.
Your lordship. And my
What is the father's name? What is the deposition of the father? Page?
lordship, page 98, your lordship.
Huh?
98.
98. Hasem Ali, Munshi.
Lordship. And my father's name has also been enlisted in the.
What about a cross examination?
Lordship, that.
You are not annexed.
No, there is no any cross examination. Lordship.
Huh?
There was no any cross examination.
Hasem Ali. DW2. He was DW2 or what? Hasem Ali?
Lordship, DW.
Okay. Let us examine then. Okay. Notice record interim.
Item number 26.
Lordship, interim will be correct. Interim.
Earlier interim.
My lord, this is the contested case, my lord. Here, this, my lord, the land document and other document were discarded, my lord. The land document where the Jawandi copy being a legal here of the father, his name was mutated, my lord, in 2005. But annexer 10, page 33, my lord.
Yes.
33, my lord.
So what do?
So, but they discard, my lord, that document, my lord.
Discarded?
Yes, my lord.
On what ground?
My lord, this is the computer generated, my lord. That is it.
System generally certified.
Yes, my lord. But signature is.
System nowadays everything is computerized. We'll call for the record then. Notice record interim.
SP what? Hello, obliged.
Item number 29 for orders.
What is it?
This is a review application, lordships. Here is the case, lordship. Tribunal declared the petition as foreigner. Then we preferred a writ petition that was dismissed on the
Where is the order of the order? Page.
page Lordship, High Court order page 66. Thereafter, we went to this Honorable Apex Court. Then also I withdraw the with the liberty to approach the court with review of the order. High Court's judgment Lordship only on approach a delay on that point without merit of the case. And here is the case, Lordship, fundamental rights are involved. I have to trust the judgment, Lordship, and isolation, Lordship. They have to look into the rights. So this is rights are involved, Lordship. There's page 66.
What is, why you want to review?
One tribunal Lordships because thereafter I approached the Honorable Apex Court. This Apex Court Lordships directed me to approach this Honorable Court. That is page 70.
It is this
Hence,
order
this
was passed when
by the Honorable Apex Court.
6/10/2020.
Lordships.
So it was dismissed on the ground of delay.
Well, liberty is given, Lordships. Needless to state that in case the petition failed before the High Court, they are permitted to approach this court once ever again challenge the main order as well as the order passed in the review petition. Last paragraph, Lordship.
Okay, we'll issue notice. Notice was issued. perhaps?
Admitted, Lordships, last occasion.
Oh, okay, but why the record? Record has been received or what?
Lordships.
Call for the record. Already notice was issued, review has been filed against or so call for records. Notice has been issued, no? No?
Yes.
Why is the order not issue notice?
Not admitted.
Not admitted.
Delay part will come, Lordship, in this.
Delay, what delay?
Delay, Lordship, original case was disposed of on 16/11/2011, Lordship. After a lapse of 5 years, he come before the Honorable Court on the ground of death, Lordship. On account of delay, death petition was disposed. After that, after a lapse of again 3 years, he approached Supreme Court, Lordship. That case was dismissed on withdrawal with a liberty to file a review petition, Lordship. After disposal of that petition, again, Lordship, again after a lapse of 1 year, Lordship, he come before this Honorable Court to file.
Anyway, then see the Honorable Supreme observation also indicative, needless to state that in case the petitioners fail before the High Court, they are permitted to approach the court over again, challenging the main order as well as the order passed in the review petition. So let us see then. We'll issue notice requisition the records. Is it Niki record? No. Call for. Say no. Is it? 564648. Okay. Records have been received. We'll examine the matter, release the matter and so and so.
Till then, I may the Lordships.
List after a month. In the meantime, if the review petitioner has not been detained on the stand of the impugned order, he may be allowed to remain on bail. Subject, however, he will appear before the SP voters and biometrics.
Item number 30. Supplementary orders.
What is this?
My lord, may I please?
Yeah.
My lord, this is an interlocutory application, my lord.
For?
This case was listed on 10/8 and notice was issued, my lord.
Yes.
My lord, the order says that I should appear before the superintendent of police on 21st of November.
Yes.
It also says that I should submit my biometrics, my phone numbers. I have absolutely no problem with that. My
Yes.
lord, my only grievance is that, my lord, this order does not reflect that I should not be detained, my lord. My lord, it also says, my lord, that however, failure on the part of the petitioner to comply with the direction specified above, the authority concerned shall be at liberty to take appropriate action in accordance with the law.
Now, my lord, if I appear before the superintendent of police, my lord, on 21st, now I have a reasonable apprehension that I may be detained, my lord, because this order does not reflect that I should not be detained.
Yes, Mr. Okay, Mr. Lane, counsel for the applicant, also Mr. Lane, counsel for the sub huh? Devi, huh? The present application has been filed for seeking a clarification of the order dated modification of the order dated 27/10/2022 passed in WPC number 6791 of 2022, by which though this court had passed an order directing the applicant petitioner to appear before the Superintendent of Police Border Borpeta on or before 21/1/2022, along with a certified copy of the order. And also provide the fingerprints and biometrics, etc. And also provide the details of her address, including her mobile number, phone number, before the SP Border Borpeta. The order does not clearly mention that she may be allowed to remain on bail on furnishing such information. They have been submitted that in absence of a clear order directing, allowing the petitioner to remain on bail on furnishing such information as directed, the petitioner apprehends that she may be detained. According to the present application is filed seeking clarification to the effect that it may be mentioned clearly that on appearing before the SP Border Borpeta and furnishing the necessary documents / information as directed by this court, she may be allowed to remain on bail. We have gone through the order dated 27/22, dated 27/10/22 passed by this court on so and so. We are of the view that since the intention of this court was to grant bail, to allow the petitioner to remain on bail on her appearing before the SP Border Borpeta on or before 21/11/2022 and furnishing the necessary documents / information as directed, comma. It is not clearly mentioned that the petitioner applicant may be allowed to remain on bail.
Yes, there was no 3% perception in the petition. That's why that order was passed.
Accordingly, we make it clear that the petitioner will be allowed to remain on bail on fulfilling the conditions mentioned in the said order dated 27/10/2022. However, we extend the period of appearance before the SP Border by another 2 weeks from today.
Between 10 AM to 4:30.
Accordingly, the applicant will appear before the SP Border within 15 days, within 2 weeks from today, or during the office hours between 10 AM to 4:30, along with a certified copy of the order.
Deeply obliged.
I had disposed of. Next.
List of orders.
List of orders. Achha, then what is the other? Huh? Oh, no DV matter now. Hearing list is there. Hearing by the same bench. Any hearing matter? Then we can continue with DB if you know, or we have a single bench also. We can. Any hearing matter? Let us see. Anybody in the hearing list? Hearing list will be criminal matters. Naki. Oh, if you do the FT matters hearing, we see, we will prefer these deaths and death reference and all this, huh? So they are more pertinent. There is a question of death and life for them. And other matters, they are perhaps mostly are on bail also. So we'll take up, if anybody is ready, so we'll take it up, hearing matters, we'll take up the criminal matters. Okay, we'll clarify it. Huh? We'll clarify today. Maybe people, yes, learned council may not be ready. Huh? Yes, PP also will be required. We have to inform them accordingly.
Okay.
You have submitted a written argument, huh?
But
Yes.
I'll make a oral submission.
Yes.
Well, if necessary, my lord, if you my lord, I can also submit the short, my lord, by Monday, no problem. Because I have only argued. And those points I can note down. A long time has passed.
It will be preferable to, yes.
My lord.
Your lordship can hear him. I shall submit that.
Yes, yes.
It can be.
Yes.
So my submission will cover the following points.
Yes.
I'm giving the points first so that I can come back to those points again and again. First, lordship, there is no, this whole thing has arisen out of an insurance policy. There's a dispute arising out of insurance policy. And as per him, he said that there is a condition clause in the policy, which he is interpreted as arbitration clause.
Let us see the clause again. If you,
Uh,
the clause which they relying as arbitration clause, page number.
Yes, Dr. Again.
Page number 44.
Page number 44 of his petition.
Yes, the company is option. All aspect as to arbitration agreement, appointment, arbitrators, terms of reference, effect will be a lands with provisions of. So they are pleased that because of this 16, 15,
According to
15
them,
clause
arbitration
of 6, para 6 or something.
Yes,
like
Lord.
that. Yes.
So my submission, lordship, is firstly, there is no arbitration clause or arbitration agreement in this particular policy issued by the respondent company. The condition number 15, which has been stated to be arbitration clause, is not an arbitration agreement or clause at all, because it does not satisfy the criteria under section 7. Then I'll have to explain if it is not an arbitration clause, why it's there. Why this condition number 15 is there, I'll come to that. Lordship, this
particular condition which says, last one is mere use of the word arbitration or arbitrator in a clause does not per se make it an arbitration clause. The words have been used, but the intention has to be read into it. The party is hereby agreed to submit the disputes to arbitration. That has to be there. The use of the word arbitration or arbitrator will not make it a arbitration agreement. The last point, Lordship, that has been argued that rule of contra preferentum, Lordship, preferentum. That if there's some ambiguity, now in the words in this particular 3-4 lines is so simple, there's no ambiguity. It's one, there is some ambiguity, that rule of that will go against the maker who has made this ambiguity, who has created this ambiguity, that will go against that rule of contra preferentum. So, Lordship, a little further, I have to go to section 7, Lordship, because that is the core of the core, Lordship. Whether this particular clause satisfy the criteria under section 7.
Yes.
Section 7, Lordship may notice, it starts with the subsection 7.1. It is the essence of the section, Lordship.
Yes.
The words in this part, arbitration agreement means an agreement by the parties to submit to arbitration all or certain aspects. These few words, 6 or 7 words, agreement by the parties to submit to arbitration, any or all. There is a second thing. Whether this also implies an intention of the parties. The intention of parties that they must come together, agree, either a separate agreement, arbitration agreement. If it is not it does not exist as a separate agreement containing signature of both the parties, then it can be also a clause within a contract. Now, this is a clause within a contract. Now, this honorable court has to see whether any such intention can be read in this particular few words. Because also the other day, when I started, I had given a specimen of an arbitration in which insurance company use all over their in all the policies. It's a very detailed, very long arbitration clause. What will be subject to arbitration? So this is not an arbitration. This probably exists as an enabling provision. Because Lordship, an arbitration agreement may also be inferred from a document. If the policy or agreement refers to a document which contains an arbitration agreement. Professor, I'll read out the section 7. That will make it clear from where all this arbitration agreement can be invoked, Lordship. Lordship, this part, section 7.1, as I've said, Lordship, means an agreement by the parties. Now, this agreement by the parties implies consensus ad idem, the contractual requirement, that is soul of the contractual requirement, the consensus ad idem has to be there. Now, this Lordship, the Supreme Court has, Lordship, analyzed number of quite a few such expressions in various cases. I'll come to that, Jagdish Chandra versus Ramesh Chandra. I'll come to. Second, Lordship, because it wanted to avoid subjectivity and bring objectivity. 7.2, Lordship, an arbitration agreement may be in the form of an arbitration clause in a contract or in the form of a separate agreement. The insistence was that arbitration agreement shall be in writing. It's not left to any subjectivity interpretation. An agreement, arbitration agreement is in writing if it is contained in a document signed by the parties or exchange of letters, telex, telegrams, and other means of telecommunication, including communication through electric means, which provide a record of the agreement. It may not be either in the agreement, but it provides a record of an agreement between the parties, that there is an intention to settle matters through dispute, or settle disputes through an arbitration. And also an exchange of statements of claim and defense in which the existence of agreement as alleged by one party not denied by the other. Like in this case, Lordship, this petition contains that there is an alleges that there is an arbitration agreement. We have denied it. If we had not denied it, then that would have been by admission that arbitration agreement exists. But we have very specifically denied. Even all letters to the company, respondent company, that let's there is a request for appointment of an arbitrator, and the insurance company has stated that there is no such agreement, they declined. So this also 7C, these are the 3 instances from where an arbitration agreement can be presumed in writing. Either it's directly there, or it's through letters, or it's there by a allegation and denial. If it was not denied, then probably not been able to argue this point. Then the reference in a contract to a document contain arbitration clause, constitution arbitration agreement If the contract is in writing, that's 7 here 5. In writing, and the reference is such as to make the arbitration clause a part of the contract. So now we have to go back to that clause, Lordship. We'll read the clause again and again to see if it can be, if any meaning emerges that there's an intention to settle disputes to arbitration. All aspects as to arbitration, appointment of arbitrators, terms of reference, award, its effect, etc., will be in accordance with the provisions of the Arbitration and Conciliation Act. Lordship, it just says if at all a situation arises where it emerges that the arbitration agreement is there, it is to be found in a particular document or through this exchange of pleadings and denial, it can be inferred, then as a safeguard, we will not go outside the provisions of arbitration conciliation. This is the reason, this is an enabling provision which is there. But this does not itself become per se become a arbitration agreement. So in this case, I'd let me take a Lordship. I had given the judgment, Jagdish Chandra versus Ramesh Chandra, Lordship. It similar such expressions have been, Lordship, discussed in detail.
Yes, Jagdish Chandra, yes.
Is there?
Yes.
Jagdish Chandra versus Ramesh Chandra. Lordship may come to para 8.4. This is an example of what is not an arbitration agreement. But mere use of the word arbitration, that's the para 8.4.
Yes.
Mere use of the word arbitration or arbitrator in a clause will not make it an arbitration agreement if it requires or contemplates a further or fresh consent of the parties for reference to arbitration. For example, if there are words such as parties can, if they so desire, refer their disputes to arbitration. Or, under example, in the event of any dispute, the parties may also agree to refer the same to arbitration. Third example, if any disputes arise between the parties, they should consider settlement by arbitration. In a clause relating to agreement, relating to settlement dispute, indicate that the clause is not intended to be an arbitration agreement. Similarly, a clause which states, if the parties so decide, the dispute shall be referred to arbitration, is not an arbitration agreement. Such clauses merely indicate a desire or hope to have the dispute settled by arbitration, or a tentative arrangement to explore arbitration as a mode of settlement, if and when a dispute arises. Such clauses require the parties to arrive at a further agreement to go to arbitration, as and when the dispute arises. Any agreement or clause in an agreement requiring or contemplating a further consent or consensus before a reference to arbitration is not an arbitration agreement, but an agreement to enter into arbitration agreement in future. This is my this particular clause. Even after reading a number of times, I could not find any intention that both the parties have declared will settle our disputes to arbitration. That consensus ad item. It also says that agreement by itself will not be valid unless it is contextually valid. To be valid contextually, there has to be this element of contextual consensus ad item. So I rely on the judgments from which I am making these statements. I'll come to the Lordship. Lordship, I look to now come to section 11, under which this particular year has been filed. Section 11, Lordship, even in this Ramesh Chandra Lordship, there is a section 11, para 11 Lordship. I'll just start with this since we are in this particular petition. I'll come to others.
Para 11 now?
Para
Jagdish?
11 is Ramesh Chandra.
Ramesh?
Ramesh, Jagdish Chandra.
Jagdish Chandra. Yes.
Para 11 is the existence of an arbitration agreement as defined under section 7 of the Act is a condition precedent for exercise of power to appoint an arbitrator arbitral tribunal under section 11 of the Act by the Chief Justice or his designate. It is not permissible to appoint an arbitrator to adjudicate the dispute between the parties in the absence of an arbitration agreement or mutual consent. The designate and that is first to the particular. So this has been, this is the other judgments, I'll come to other judgments, which is before exercise of power under section 11, that existence of arbitration agreement has to be decided by the High Court. So to that extent, Lordship, I'll take your Lordship judgment. Because there is 7 judges bench. Lordship in SBP and Co. versus Patel Engineering Limited and another. Which is 7 judges. This judgment is basically.
What is the judgment? Name? Party name?
SBP and Company versus Patel Engineering Limited and another. It's there.
Yes, yes, please give a copy. Yes.
We come to para 39. There are other paras, but I think I'll come to this one first. It is necessary to define what exactly the Chief Justice approach with an application under section 11 of the Act is to decide at that stage. Obviously, he has to decide his own jurisdiction in the sense that whether the party making the motion has approached the right High Court, then he has to decide whether there is an arbitration agreement as defined in the Act. And whether the person who has made the request before him is a party to such an agreement. Again, Lordship, whether the power of the Chief Justice or the Honorable High Court is a judicial or administrative power, that has been discussed very clearly in this judgment. This whole essence of the judgment is this, that whether this power under section 11 is a judicial power or an. It has come to the, it's a judicial power and only the CJI can delegate to another judge, not to another, not to any other person, but the judge. There are 44, Lordship, I'll just touch upon this point and leave it. Once we arrive at a conclusion that the proceeding before the Chief Justice, while entertaining an application under section 11(6) of the Act, is adjudicated, then obviously the outcome of that adjudication is a judicial order. Once it's a judicial order, the same as far as the High Court is concerned, it will be final. And the only avenue open to a party feeling aggrieved by the order of Chief Justice would be to approach the Supreme Court. It cannot be, his power cannot be delegated to anyone. It has to be challenged in Supreme Court. Lordship, same judgment, Lordship, I will come to this.
Yes.
Para 20, Lordship.
Of this, huh?
In fact, I'll go to the previous para 38. It will be more illuminating, para 38.
Para?
38, that just read out the 39, just the prior to the previous paragraph.
Yes.
There are 38. It is true that finality under section 11(7) of the Act is attached only to a decision of the Chief Justice on a matter entrusted by subsection 4 or subsection 5 or subsection 6 of that section. Subsection 4 deals with the existence of an appointment procedure and the failure of a party to appoint the arbitrator within 30 days from the recipient of a request to do so from the other party, or when two appointed arbitrators fail to agree on the presiding arbitrator within 30 days. It is section 8, Lordship, basically. Subsection 5 deals with the parties failing to agree in nominating a sole arbitrator within 30 days of the request in that behalf made by one of the parties to the arbitration agreement, and subsection 6 deals with the Chief Justice appointing an arbitrator or an arbitral tribunal when the party or the two arbitrators or a person including an institution entrusted the function fails to perform the same. The finality at first blush could be said to be only the decision said to be only on the decision on these matters. But the basic requirement for exercising his power under section 11(6) is the existence of an arbitration agreement in terms of section 7 of the Act, and the applicant before the Chief Justice being shown to be a party to such an agreement. It will also include the question of whether of the jurisdiction to it. But it again reiterates the same thing, that existence of an arbitration agreement has to be decided by the Honorable Court.
Yes.
I'll come to this shortly. So Lordship, I'll come to this rule of contra preferentum, Lord. That has been argued, that was argued on the last day, that it appears to be ambiguous, therefore that's why this rule of contra preferentum must be invoked to decide that it's the respondent insurance company has failed to provide a clear case, then it should go against them. But Lordship, my humble submission, this is the rule of contra preferentum cannot be firstly invoked here. For one reason, there is no ambiguity. The ambiguity has to be derived from the whether there is an ambiguity or not. That is derived from the words or the sentence or the expressions, clauses, sub-clauses. This appears to be very clear now. And if we read that particular one, try to read that particular expression, agreement to submit to arbitration, that is not there. So this particular clause, Lordship, I will come again, Lordship. Lordship, there's another judgment that is I would like to refer to, National Insurance Company versus Bokhara Polyfet.
National Insurance versus
Bokhara Polyfet. Boghara.
you have not provided.
Yeah, I'll provide. Okay, they're in the back. I'm getting it. So this is the case where the existence of the arbitration clause itself was not in doubt. Unlike this case where we are doubting the existence of the agreement. In order to explain the rule of contra preferentum, I have to come to this judgment, Lordship. This judgment says one thing, Lordship, para 16. Para 16, in fact, relates to section 16 itself. Lordship. Para 16 of the qualified. Also corresponds to section 16 of the Act. It discusses about section 16. Para 16 somehow rhymes with section 16 of the Act. Section 16 Lordship of the Act says, Section A, an arbitration clause which forms a part of the contract shall be treated- Lordship, para 16 of that judgment,
Page number,
page number 6, Lordship.
National Insurance, Bogra Polyfab.
Yes, Lordship. Maybe Lordship judgment, para 16, page may differ, Lordship.
This 27, SCC 2009.
Yes, Lordship, 2009.
2009 volume 1 SCC 267.
Yes, Lordship, para 16.
Para 16 is at 279.
279. I downloaded from a different.
Okay, you are reading, what is the
Para 16.
beginning of the sentence?
In Union of India versus Kishore Gupta.
This court considers the question.
That was from SCC. I am quoting from STP.
Okay.
But this discusses, in fact, section 16 of the Act.
Yes.
Section 16 very clearly says, an arbitration clause which forms a part of a contract shall be treated as an agreement independent of the other terms of the contract. This has to be read without reference to other. The ambiguity will come also, may come when it is a conflict with other terms and conditions of the particular policy. It says no, it has to be treated separately. And this is very clearly explained in this particular judgment, Polyfab by company. Para 16 of the judgment says, an arbitration clause in Union of India, this court considered a question and whether the arbitration clause in the contract will cease to have effect when the contract stood discharged as a result of settlement. There are also some principles have been here. One principle is also an arbitration clause is a collateral term of a contract distinguished from the substantive terms. Whether we have said something different in the previous terms and sections of the policy would not clash with this. This stands by itself. But nonetheless, it's an integral part, but it cannot be compared to the other. However, complete the terms of an arbitration clause may be, the existence of the contract is a necessary condition for its operation. It's arbitration, the arbitration operation. Plus in para 17, it analyzes the nature of the clause, Lordship. It's a clause within a contract and why it's different from the other parts of the contract. Para 17, Lordship. The decision in Procedural Gupta was followed and rated in several decisions, including Naithani Jute Mills and Khailiram Jagannath, Damodar Valley Corporation versus KKR, and this thing others. In Damodar Valley Corporation, this court observed a contract is the creature of an agreement between the parties. And where the parties under the terms of the contract agree to incorporate an arbitration clause. That clause stands apart from the other rights and obligations under that contract, as it has been incorporated with the object of providing a machinery for settlement of disputes arising in relation to or in connection to the contract. Because what are the merits of the policy? There may be disputes regarding whether something is payable, not payable, or whether one part of the policy conflicts with the other part of the policy. Those will be different, but this is a mechanism. Not to be considered whether that other part, what we have said in other parts, will not also impact this particular. This clause has to be, it stands apart, has to be interpreted without reference to other terms and conditions. In any case, Lordship, the contra preferentum rule that also arises from the one judgment, United India versus Orient Treasures. This rule has been discussed here.
In
United India Insurance Company versus Orient Treasures.
United India Insurance versus
Orient Treasures Private Limited.
Have you given that? No.
Yes, yes.
Which judgment have you given?
This one. It discusses contra preferendum rule, that what has been discussed. Lord Impellar. There are 37 laws. In Halsbury's Laws of England, principle of contra preferendum rule.
Anyway, we'll continue. We'll continue.
Yes.
কিমান দেখুৱাব আপুনি আৰু ৰেফাৰেঞ্চ নকৰি কেনে আমি কেনেকৈ লিখিম ৰেফাৰেঞ্চটো ক'ব না সেইটো অৰিয়েণ্টেড
Para?
37. I just began at the.
Yes.
In Halsbury's Laws of England, principle of contra preferendum rule is stated as thus. Contra preferendum rule, when there is ambiguity in the policy, the court will apply the contra preferendum rule. Where a policy is produced by the insurers, it is their business to see that precision and clarity are attained. And if they fail to do so, the ambiguity will be resolved by adopting the construction favorable to the insured. As similarly, as regards language which emanates from the insured, such as language used in answer to questions in the proposal or in a slip, construction favorable to the insurers will prevail if the insured has created any ambiguity. It's both ways. This rule, however, only becomes operative when the words are truly ambiguous. It is a rule for resolving ambiguity and cannot be invoked with a view to creating a doubt. Therefore, where words used are free from ambiguity in that sense, in the sense that fairly and reasonably construed, they admit of only one meaning, the rule has no application. I'll come to Lordship para 38. In the aforesaid rule, in a consideration that has no application, that's to the facts of this case, that to the particular that case. Para 39 Lordship. It's a settled principle, settled rule of interpretation that when the words of a statute are clear, plain, and unambiguous, they are reasonably susceptible to only one meaning. The courts are bound to give effect to that meaning, irrespective of the consequences. In other words, when a language is plain and unambiguous, it admits of one meaning, only one meaning. That no question of construction of a simple statute for the act itself arises. Lordship, here, Lordship, I beg to submit, Lordship.
Yes, yes.
In the particular condition number 15 that we have been discussing, Lordship. Lordship, if I may read that again, Lordship would see. There is no
Yes.
ambiguity at all in this case. That particular paragraph, Lordship.
So you-
Condition number
You mean
15.
to say that except for this para 15, which mentions of all aspects as to arbitration appointment, but there is no other clause which says that if any dispute arises,
Yes, sir.
it shall be referred to arbitration.
Yes.
Apart from this general, you say that
This
is a very
is an
general.
enabling provision, Lord.
Why it was inserted? Any idea?
It's like in the Jagdish Chandra's case, it was
Huh?
like in the other case, Supreme Court Jagdish Chandra versus Ramesh Chandra. It was there, the explanation given, just to explain. If at all there is a arbitration, arbitration emerges from letters, correspondences, or in a document which is referred to, or in the written statement, and the plain and the written statement, which was not there's an allegation in the plain that there is an arbitration agreement, and the respondent insurance company does not deny it. Then this will come into it, because then it will be admitted that there is an arbitration agreement, which is not denied by the insurance company. Therefore, this, in that case, this will be they wanted to be placed to be within the act.
So according to
Yes,
this section 15.
Yes.
Apart from this section 15, there is no other clause,
Yes,
any term under any of the clauses where there is any reference for arbitration.
Yes. I'll show it the other way around, Lordship. The Lordship Hyundai engineering that I had given the other day, Lordship.
Yes.
It's the same clause that is interpreted in a number of cases relating to insurance policy.
In Hyundai, this
Para number
United-
2 of United Insurance Company versus Hyundai
Ah.
Engineering
Ah.
and Construction Company.
there's something like this. There's some reference to arbitration.
No, this
No.
is the proper arbitration clause which is there, which appears in insurance policy. And there this particular wording does not appear because it's clear that they want to go for arbitration. Only when it is not there, this has appeared, this doesn't appear anywhere. They probably wanted a safeguard here. If at all arbitration arises, then they would be bound by the act, not any other provisions. Look, what is, I'll read out the paragraph 2.
Mhm.
The policy contains clause number 7, which reads thus. If any differential arises as to the quantum to be paid under this policy, liability being otherwise admitted, whereas liability is not open to arbitration, such difference shall be independently of all other questions be referred to the decision of an arbitrator to be appointed in writing by the parties in difference, or if they cannot agree upon a single arbitrator to the decision of two disinterested person as arbitrators, of whom one shall be appointed in writing by each of the parties within 2 calendar months after having been required to do so in writing by the other party in accordance with the provisions of the Arbitration Act 1940.
So there is a provision for arbitration here.
Not in this policy, in this particular judgment clause.
In this judgment,
Yes.
para 7, in this judgment, Hyundai Engineering,
Yes.
when a dispute arose, in that agreement,
Yes.
there is a clause 7,
Yes.
which is quoted in para 2.
This is the standard agreement.
Now, of course,
In
if it
all
is there,
insurance
is very
policies,
loud
that
and
are-
clear.
So other insurance for-
No,
cases-
what we want to know is that very loud and clear
Yes.
that there is a provision. So there is no escape, there is no question of
No,
any.
you cannot escape.
But then, is there any judgment
Yes, Lord.
where agreement there, but without any reference to arbitration, that dispute will be referred? But then there is a sentence like this: all matters relating to arbitration will be considered in accordance with the Arbitration Act. Is there any other apart from your case?
Similar expressions have been discussed also in the Jagdish Chandra's case. Lord.
In Delhi
Jagdish
Chandra's,
Chandra that I have already discussed. Also.
there
Yeah, Lord, all similar cryptic years are there without any arbitration clause as such.
there
Jagdish Chandra
that
also with the section para 9, 4, subsection 4. Jagdish
but
Chandra.
mere use of, no, correct. This is the law which the law, they are laying down the law. But in that case, in that particular case of Jagdish Chandra, what was the facts of the case? We have
That's a partnership deed, Lordship. That contained a
in
clause, clause 16.
that permission, clause 6 of the deed, no?
Yes, Lord.
Which is mentioned para 2.
Yes, Lord.
Clause 16 of the said deed relates to settlement dispute. If during the continued participation of dispute, the same may be mutually by parties shall effort to arbitration if the party so determined.
Shall be
If the
referred for
party so
arbitration.
determined. If the party so determined, that means if the party so agree.
I agree.
If during the continuation any dispute, the same may be mutually decided by. So this party so determined, it requires an agreement according to this Jagdish Chandra.
Yes.
Whereas arbitration agreement means an existing agreement to refer to arbitration in case of dispute.
Yes.
There are in
So
which
different
event
only-
in which event the arbitration act will apply. But where is merely provision to agree.
Yes.
If you want to decide, you may not agree also. You may decide, no, we'll not go the arbitration.
Both ways, if you like.
Okay, we'll go the normal way. Both ways are there. So in such an event, the arbitration clause cannot be invoked
Cannot be
without there being a prior agreement.
agreement. That agreement to refer to arbitration.
Mere existence of agreement to refer.
Yes. Sir. Now, if there is an agreement to submit disputes to arbitration, that's heart and soul of the provision section.
Correct, correct. If there is already an
Yes.
agreed term that yes, it will be referred,
Yes.
then agreement, then
That's an
agreement. But if they have to say, if there's, if that agreement is yet to be arrived at, but
is
there is a
not
provision for enabling.
Yes.
If there is an enabling provision to agree to refer to arbitration, then you cannot straight away resort to arbitration. That is what your submission
That's
is.
my submission.
Yes,
In
yes.
This same judgment, it discusses a number of similar expressions.
Therefore, as a consequence, as a corollary, what you are saying that even if there is some clause like this,
Yeah.
that any matter, you are closing all aspects as to arbitration agreement, appointment, arbitration should be referred to in accordance with the provisions of Arbitration Act. Okay, yes, sir.
Because there's always possibilities exist that does not appear in the contract of insurance, but it can appear in a document. There's a reference to document where there's it can occur in exchanges of communication there. Or maybe it has been alleged in the plaint and the insurance company has not denied it in the written statement. These are situations when court may come to a finding, yes, there is a arbitration agreement, you have not denied it. Then these will be the boundaries, parameters. This is the idea. We'll go by this. Sole arbitrator, other two arbitrators, then there is a third, then if not, then they will come to the High Court under Section 11. While talking of contract referendum rule there, other things I just give, I'll not discuss it, but it says the same thing. I just want to give one citation and. This another segment on that where words of the clear are very clear. So I'll not take up time by discussing this procedure here. I'll be concluding this argument with just reference to one yellow, the Bidda Drolia versus Durga Trading Corporation. Reference to what?
This is para number, relevant para. In this case, you cited.
Para 11, 12, and 13.
Okay.
12, 13, 14. 11, 12, 13, 14.
What is there in 11, 12, 13, 14?
I'll just say that.
No, just tell us. 11, 12. Insured cannot claim anything more than what is covered by insurance policy.
The terms of the contract have to be construed strictly without altering the nature of the contract as the same may affect the interest of the parties adversely. Then in under one in Vikram Green Tech, it says that talks about insurance contract is a specimen of commercial transaction and must be construed like any other contract to its own terms and by There's no lots of liberalism to be adopted.
So according to you, under this term,
Yes, Lord.
in this agreement in issue, there is no confusion, there is no ambiguity
No,
as far as
Yes.
referring of any dispute to arbitration is concerned, because there is no such agreement, there is no such clause.
Exactly.
That is okay.
But this para 13 of the same judgment, let's say, I'll just read out para 13. This makes it very clear.
Yes.
Thus, it is not permissible for the court
Yes.
to substitute the terms of the contract itself under the garb of construing terms incorporated in the agreement of insurance. No exceptions can be made on the ground of equity. Liberal attitude adopted by a court by way of which it interprets in the terms of an insurance agreement is not permitted. The same must certainly not be extended to the extent of substituting words that were never intended to form a part of the act. More or less reaffirming, retaining what I've said. If the words
Just
not
like
same-
you cannot read into, you cannot read more into
the words that are there.
but similarly, you also cannot ignore
Yes,
so two things are there. You cannot read more
We cannot read more.
into a specific language. In a sense, there is no, but you are also deleting this clause 15 also, but you are ignoring it.
Clause 15.
Clause 15 also, according to them, you are ignoring it. If you don't, you have to read that also.
In fact, this does not lead to that conclusion that the parties have
So
admitted.
you say that even if you read
Yes,
clause 15,
Yes,
it doesn't lead anything.
yes, Lord.
Uh,
It doesn't lead to that meaning.
Lead
That
any-
is to refer disputes to arbitration.
Uh.
There's no way, it's just simple words, 10, 12 words, doesn't lead to any conclusion. By a number of permutation combinations of clauses, words.
So it is redundant, that means it is redundant.
It's just
It is the
enabling
redundant
provision.
clause.
It's an enabling clause. There are judgments where such enabling provisions are to be found.
So this is not redundant, but it's an enabling clause, not redundant.
Not redundant, because in all policies, lordship, I'm saying,
Is there any instance where the company has resorted to arbitration? No, at any point of time, no.
yes, lordship, in fact, in course, we decided by in
No,
one.
no,
of the
in
decisions,
your
this
case,
was
in
by-
your case, you are a United Insurance, no?
Yes,
In United Insurance company, do you also resort to arbitration?
yes, lordship, in one case decided last month by your lordship.
Yes, sir.
Golagat team, United Nations versus Golagat team makers.
Okay.
Without a doubt, without a word, lordship, I said, yes, let's appoint arbitrator.
No, but I know, was it appointed by the court or it was agreed by the party? Huh?
PD Agarwal for this case, that I'm talking about.
No, but then both the parties agreed, that is why.
Both the parties agreed. I did not even utter one word of it.
Okay,
We but just discussed a few names, then suggested to your lordship. to appoint.
okay, okay,
It's not that each and every time we come for with objection.
okay, okay.
That
In
is
this,
very
this case, you are specific,
Yes,
there is no
yes,
such
this is
instruction
not-
to agree to arbitration.
Yes. That Golagat team makers, it was disposed of in 5 minutes, we would place 1 minute.
Here also you could have done, I mean,
Had
here
it
also,
been-
had
it
you,
been there, I would have
had you got the instruction, you could have done.
done.
It will be also in consonance with this clause 15, where it enables you to,
Clause 15 others do not appear in other policies. They straightway come as arbitration clause like Hyundai engineering.
I see, in other policies.
Where this clause does not appear in other policies, because
In your company's case.
yes, in all insurance companies, they have the same.
In all
Standard
insurance.
policies are, these are tariff policies mostly.
Achha,
Yeah. They appear in all tariff wording has to be same. All India tariff committee regulate the insurance market.
So you mean to say this is not unique to your insurance company, to all insurance company also has this kind of similar provision, enabling provision?
It's also on the next day, I'll submit.
You mean to say that this is the first time in Guwahati High Court this issue has arisen? You say that this is a very common clause in not only in your insurance company, but all other insurance companies.
Clause 7
Ah.
appears, arbitration clause appears in most major policies. Like we have small little policies where it doesn't appear. But here, instead of this appear, they wanted it that way. Probably the entire whole policy wording was framed like a premium was collected in that manner. There's underwriting considerations are there, where they want some policy conditions. They do not want this. These are subject to underwriting exercise. Big lots of chartered accountants are actuaries. They actually make actual calculations and do it. So this is not there by design. This may be a matter of interpretation for civil courts, whether this can, but if there on this topic, this court would be concerned with this particular clause only. Apart outside this court, let's say it will be interpretation of consumer court, civil courts.
So you mean to say that there has been no case decided, though this clause is common to all kind of agreement, many.
I know about this. There may be on the next day, my friend will come with here. I'll also try to come with
You can-
more such
because-
more such insurance cases where it was there, but it is not.
Okay,
On the next day, I'll come with that.
okay. Yes. Yes.
Hello. My lord,
lord, what my learned friend saying, my lord, that this is not the arbitration clause. My lord, I for myself, my lord, why this is a commercial contract, my lord. This is the insurance, my lord, for insurance of my crop. And the clause contains in a place where, my lord, if your lordships just see previous two clauses also, 13, 14 also, complaint to police authority is mandatory in loss occurring due to burglary, a housebreaking, attempt, so and so loss damage caused by the party. Insurer shall render full cooperation to authority in prosecuting and so and so. 14, the company has option pay for or reinstate or repair the property up to the amount specified in the policy, or is less, subject to admissibility of the substantial the loss satisfaction of the insurer. After this clause is there, my lord. All aspects as to arbitration agreement, appointment of arbitrator, terms of reference, award, its effect will be in accordance with the provisions of the Arbitration and Conciliation Act, which amendment. My lord, why this clause has been incorporated in this, at this place? When there is some burglary or other things are there, they will pay for it. If anything is there, then arbitration comes.
See, one thing, Mr. Saywala also.
Yes.
When arbitration clause is what? Arbitration clause is just an alternative forum to
Correct.
dispute resolution.
Correct, my lord. That is the-
If that is so, first of all, there must exist a dispute.
Yes.
Number two, there must somebody must has raised that dispute to be resolved.
Correct.
When both the parties, either one of the parties ignore
Yes.
or both parties do not act,
Yes.
then one of the parties invokes the forum rather than going to the court.
Yes.
Invokes the arbitration
correct,
clause.
correct.
Now your point, because this has to be
My
resolved.
lord, my lord.
Now, therefore, when do you, under this agreement,
Yes.
when a dispute can said to have arisen, if that is so, when onus lies on the other side to respond,
Yes.
is there any mechanism?
My lord, yes.
And
My lord, I'm
yes.
submitting. My lord, here what happened, our claim was there. They settled it at the lesser amount. Then, my lord, we issued a letter under section 21 to appoint an arbitrator. That you will also find at page 145. That reply is very important, interesting, my lord.
So you raise a dispute when?
On 26 November 21.
On 26 November
21.
2021.
Notice
At
under
page
section,
number?
notice under section 21, page 145.
Page 145. Notice under?
Section 120, 21 of the Arbitration Act.
21, Arbitration Act.
My lord, to appoint arbitrator.
Hmm.
Then the,
No, to appoint arbitrator is one thing,
yes,
but a dispute must first arise.
this would
What this arbitrator will do?
No, we,
So first a dispute must exist.
my lord, we have written this
See,
letter, page
any
133, my lord.
any lapse, deficiency on the part of one of the parties
Yes.
does not necessarily mean that the dispute arises. And because I may say, okay, doesn't
That is
matter.
page 133,
If you are a car manufacturer,
correct, my lord.
you said I sell this car for 1 lakh, I pay 90,000,
Yes.
and you say, okay, you accept and give the car, no dispute.
My lord,
But you say, no, you have 90,000, you have given, I have 10 lakh, you have to give. Why you're demanding? I said, no, I thought I saw your paper here, discount 10% discount, that's why I came and so a dispute arises, there is another thing.
Absolutely correct.
Therefore,
That is at page 133, my lord.
page 1,
133.
133. Settlement of claim policy. While enquiring still under a film, we also cannot dispute the
That issued, my lord, they replied it.
file acknowledging a receipt.
Yes.
Since without dispute correctness, legally settlement of genuine intimidated by scientific further without prejudice category denying dispute so and so. So you raise the dispute for the first time on, this is on
My lord, I'm.
Yes, this is a different page, 133.
6 to 2.
6.
I'm just.
Yes, yes. Correct, correct.
996 2000.
96
2020.
96. Why do we get it?
Well,
Where?
page 133.
133. No, 133. What is the date? Date.
Yet, my lord, they have received it 96 2020. 2020. Left hand side, bottom.
Oh, received on 9/6/20.
Nice.
Received on 9/6/20. 20 what?
20. 20 only, my lord, 2020.
Okay, 20. Okay, 2020. Yes. This dispute. Without prejudice, we were availing insurance company. We had informed so and so difference, error in approach. We made erroneous. In view of the effort, state survey report requires to review genuine so and so. Further, we require now seeking to sell all listeners by limiting those so and so. Which is wholly untenable. Accordingly, we are request to review decision convention and by companies. So, you are any capping. So, till now, there is no mention that arbitration in your letter.
That is not.
No, there is no mention.
No.
So
we asked them
then after that, then what happened after this notice was issued?
They
What is
issued
the response?
Yes, page 141. No, I'm so I'm sorry. Well, then we have issued. They did not reply, my lord.
They didn't reply.
No. They have not.
So
then we issued another letter.
No response.
No.
No response to this letter.
Yes.
Served on 9/6/20. Then
we issued another letter at page
another
141.
letter, huh?
Yes.
Issued another letter.
Yes, this is
on
what request under protest to release the amount which was released.
This one 11 August.
Yes.
11 August.
Yes.
2020. Issued another letter.
Yes.
What is the letter? Request,
No,
protest.
request for release of the amount which were fixed under
Okay.
protest.
Letter. Then
Under protest. Then we have issued a letter.
demand. You then again demanded. And DIM has accepted no, so it can state a request for release of the shall not be continued with so and so, so and so.
Yes.
Which were we without prejudice and request to release the amount settled.
Yes.
So again, demand. Then
143, my lord, we have issued Chief Grievance Redressal Officer of United Insurance Company. That is at page 143.
Notice issued on
18/11/2021.
18/11/21
to Chief Grievance Redressal Officer.
To the Chief Grievance Redressal Officer
for review of the assessment.
For review of the assessment.
Yes.
Now, what happened to that after that?
No, nothing, my lord, no reply. Ultimately, we have to issue the section 21 notice. This 145.
No, but you, for the sake of repetition, a matter to page 144.
Yes.
Pursuant in the matter to be noted, have you a while different. You would therefore request to review the assessment according to justice.
My lord, because they have assessed lesser amount. That is why we have.
So then,
my lord, we have issued the notice under section 21.
So issued notice under section 21 arbitration on 26/11/21.
Now
What,
they have,
what do you say in condition so-and-so, solemn so-and-so, so-and-so? Illegal and our having failed to, we hereby invoke section 20 arbitration to read with close heading consensus and so conflict dispute arising for arbitration. So you call upon to resolve the dispute through arbitration. Now
their reply maybe.
their reply, yes. Let us see what did they reply.
Yes, that is the important, my lord. I'm just reading it.
Reply of the insurance respondent. Well, yes.
With reference to your notice that is so-and-so regarding reference of the disputed subject, etc., we wish to inform you that the following two reasons among others, arbitration does not appear to be appropriate forum for resolution of the perceived dispute. First one, they say, since the claim has been paid in full as per in limit stipulated in the policy as per policy terms and conditions, it cannot be said that there is a dispute on quantum of compensation. The enhancement that you are seeking relates to interpretation of the policy condition in the garb of difference in quantum of compensation. This is one. Secondly, it may please be noted that there is no arbitration clause in the compact insurance policy as usually found in other. Well, may not be. That is your feature. Other state general policies. This is also drafted by you, not by me. Why this clause has been put? What is the intention of the parties? They have said that it is not just like other policies. And secondly, say it is settled position of law that when there is no arbitration agreement between parties without a joint choice. So they say that it is not just like other clauses. Can it be said, my lord? The author himself said that it is not just like other clauses. Why he has put it? And that too in a proper place where the dispute arose.
So they are pleased that
yes,
so there is no dispute agreement. This arbitration clause. That's what they are replied in 21st of December.
So they say, my lord, first one, they say that they have paid in full. That is another aspect. Whether paid in full or not, that is decided by.
Yes.
Secondly, it may please no arbitration clause in compact insurance policy as usually found in other general insurance policy. May not be. In other policies, what language you are using, I am not known. In my policy, you have used this language. You are the author.
Yes.
My lord. Now, I put myself, my lord. Why this clause 15 is put there, my lord? But the intention of the parties. Why? Why they have put it?
If they say it is not arbitration clause for applying the dispute to arbitration. But the intention to put it there.
Yes.
An arbitration, my lord, agreement need not be required to be in any particular form. That is what always say. Your losses, I have referred to my lord, 2015-13 SCC 477. I shall refer to two paragraphs again, my lord. Your losses, ma'am.
Which judgment?
My lord, 2015-13 SCC 477.
Name.
Name, my lord, Gobind Rubber Limited versus Liquid Device Commodities. I have submitted. I shall place two paragraphs only, my lord, 17 and 18. No.
Yes.
We are also of the opinion that a commercial document having an para 17.
Yes.
Your losses may just.
Hmm.
We are also of the opinion that a commercial document having an arbitration clause has to be interpreted in such a manner as to give effect to the agreement rather than to invalidate it. On the principle of construction of commercial agreement, Stratton on Charles Partridge explained that a commercial agreement has to be construed according to the sense and meaning as collected in the first place from the terms used and understood in the plain, ordinary and popular sense. The learned author has also said that the agreement has to be interpreted in order to effectuate the immediate intention of the parties. Similarly, Russell on arbitration opined that relying on extra companies so and so, that courts should, if the circumstances allow, lean in favor of giving effect to the arbitration clause to which the parties have agreed. The learned author has also referred to another judgment of so in order to emphasize that in construing an arbitration agreement, the court should seek to give effect to intention of the parties. The apex court in Union of India versus so held that a commercial document between the parties must be interpreted in such a manner as to give efficacy to the contract rather than to invalidate it. Learned judges clarify by saying that it must be remembered that a contract is a commercial document between the parties and it must be interpreted in such a manner as to give efficacy to the contract rather than to invalidate it. It would not be right while interpreting a contract entered into between parties to lay parties to apply strict rules of construction which ordinarily applies to a conveyance or formal document. The meaning of the contract must be gathered by adopting common sense approach, and it must be allowed, must not be allowed to be thwarted by narrow, pedantic, and so, my lord, is 17 absolutely clear, my lord, that is to be interpreted commercial document, the commercial document.
But
Why?
in para 19 of
Yes.
your judgment,
Yes.
last
Yes.
line,
Yes.
the request for amendment was accepted by the respondent.
Yes. That is another mistake, my lord.
Huh?
Here we have not made any request for amendment.
No, amendment perhaps incorporate some, what is the amendment about?
No, this is
Though the appellant issued
this case,
purchase order on
respondent
terms and
issued
conditions of
sales
the appellant request respondent to change the payment terms when the sale contract.
That is another aspect. my lord. Yes.
But
Payment term.
in this case, what was the argument, arbitration clause? What do you find the facts of the case? Was it a very clear, what kind of in water?
Yes.
If you put lemon, it becomes lemon juice. If you put tea leaves, then it becomes tea. Whatever you put, you add milk becomes, see, adulterated milk, which, so,
No, that is correct. but,
so the principles are there.
Yes,
Obviously, the facts,
no, that has not been. quoted, my lord.
yeah, we just want to know. If he's not there, then otherwise, okay, no problem. But if what are the facts of the case?
Actual matters were hearing of business of Mumbai, my lord.
After hearing, hence,
Purchase of metal.
exchange didn't have any jurisdiction. He didn't have jurisdiction. There is a common laws, agreed to acceptance. No, but then, see, please come to last part of para 5.
Yes.
By the said letter, the appellant laws its counterclaim on a first party for and also agreed for acceptance of nomination of Mr. Leon Tim Fook as the sole arbitrator. So there appears to be some kind of, agreement.
Yes, naturally.
So, but here,
That has not.
they, instead of agreeing, this insurance company said that, sorry, there is no agreement is there, and it is no, arbitration is not the proper method.
Correct.
By the said letter, after law is counter on the so agree to acceptance. Can you cite any judgment where very ambiguous as per the arbitration clause it?
My lord,
But then
that is why, my lord, I'm referring to the three judgments of the
no,
contra.
Govind Rubber, you are just referring now.
Yes.
There may be some ambiguity about some other parts of the contract, but then at least here see, appellant laws the counterclaim and also agreed for acceptance nominees. So there's some kind of agreement to settle dispute by arbitration. In that any other case where you would like to, even if not the similar facts of the case, but yet there was no such specific.
Well, that is why I have relied on contra referendum. That I relied on three judgments. The latest judgment of 22 is also there. My lord, what my learned relied on, that is also referred to there. My lord, first I have referred to 2009 to SCC page 55. My lord.
But then the doubt about certain doubt means that something is there, but you are not sure. Doubt, when nothing is there, there is no question of doubt. No? When it is totally void,
My lord,
so void is void.
My lord, here.
Now, when you say doubt, oh, that looks like, but it's not this doubt. Then in a distance, you think he's a man walking or he's a giraffe walking. We don't know because somebody is walking in a distance, doubt.
Correct.
But something moving. You can see some image, maybe cat, dog, we don't know, but at distance, somebody is walking, you feel that yes, or a child is crawling, doubt.
My lord.
But not clear.
Yes.
So here, is there any reference apart from this clause 15? That no.
No other clause, my lord.
No other clause.
No other clause, because that is the, my lord, payment of compensation under insurance policy. And in that, my lord, after those two clauses, this has been put.
Because arbitration also means there must be an agreement between parties.
Yes, my lord, a clause into the contract. My lord, subsection, my lord,
It can be a it can be a separate clause.
Yes.
It is arbitration clause itself is also a part of the contract.
Yes.
But it is a again independently,
Maybe.
executable
My lord.
term. Now on its own it can be executed.
Subsection 2 says, my lord, arbitration agreement may be in the form of an arbitration clause in a contract or in the form of a separate agreement.
Yes.
So it's a clause in the contract, what I am submitting. And now, if you'll also see the last judgment, my lord, 22, contra referendum, I have referred three judgments. That is very clear, my lord. This is very clear. This should be interpreted in against the party who has
drafted it. It
That
is the one who creates all the doubt.
Yes.
He has created all this
my lord.
see, confusion.
Yes.
They are the one who should clarify it.
Correct.
And in the clarification, it should be in favor of the insurer,
yes.
the other one, other than the drafter.
And 22-4, it is a, my lord, latest judgment, my lord,
Hmm.
long judgment by Justice Chandra, my lord.
I think we have a reference, something like that.
My lord?
Today there is a reference. I think.
At 3:30.
Yes, yes. Reference is there. my lord.
Are you through with your argument then? Are you through with your argument or?
Yes, yes, that can be, my lord.
Okay, then if you can just give your short.
lord, yes.
Anything you like to say, Mr. Goswami? In response, huh? He has just reiterated what he had argued
Yes,
earlier.
I have not.
He has not added anything.
Anything.
Anything you want to say, Mr. Goswami?
I could have said something, but since there's time doesn't permit.
No, tell us very quickly, but very quickly. What do you want to say? Tell us.
Look, I just summarize lordship. There's no agreement in the policy. There's no ambiguity. And lordship, what is there is an enabling provision only. And lordship, it has to be considered
So
as
you
a-
are saying that no arbitration clause,
no arbitration,
no arbitration clause. Number 2, no ambiguity.
no, that condition of 15 is not an arbitration clause specifically.
15 is not an arbitration clause.
There's no ambiguity.
No ambiguity.
And this clause must be, any arbitration clause must be treated separately from the rest of the document because it's a dispute resolution mechanism only.
Hmm.
The others relate, other terms and conditions, policy related rights, obligation, duties, etc. of the parties, between the parties. So this cannot be influenced by other terms and conditions of the contract. What is that? This simply exists as a dispute resolution mechanism. Whatever be the nature of the whole policy might go out because of some other reasons, but this policy will stand alone without reference to any other conditions.
Okay.
And lordship, I've already referred to the standard arbitration clauses in various cases. I've just shown one, I can show others. This is a standard arbitration clause in all instances. If it was not there, it was not there by design. It's not an accident or a slip of printing the printers did. It's by design because these are subject to actual calculations, underwriting consideration. If it is not there, it's not there. If it is there, like we have said, is as in found in other policy. It is there in other policy. We are not saying that we are strangers to arbitration. Insurance companies there are cases in fact in Supreme Court relating to arbitration. Not denying the phenomenon, but this particular policy is not there.
Yes.
Lordship,
Yes.
my number is not reached.
Correct. See, we still have 1 hour to go. Unfortunately, these things do happen in life. What happens in life, nobody can predict. See, the unfortunate certain thing has happened to a member of the senior member of the bar. So, which necessitated holding of this full court reference. Otherwise, we would have been sitting till 4:15. But we had no idea when we fixed the date last time. That's why we fixed this some Parhad matter also. This is also Swami.
Then may it be fixed in the next early hearing, Lordship.
You tell us, suggest, because I say, since you are appearing person, we'll give the benefit of fixing the date by
Possible
yourself.
Tomorrow or day after tomorrow, Lordship.
No, that because we have the court also has certain rules again, because we have arbitration days only on.
Monday.
When are the men,
14.
No, which are the days where we have arbitration matters?
On 14 and 16 next week.
Okay, 14 and 16. 14 and 16, that means we have on Monday and the Wednesday, Naki? No.
Yes, Monday and Wednesday.
Monday and Wednesday, these are the allocated days.
May kindly be for Monday, Lordship.
Which Monday?
This coming 14, Lordship.
14 Monday. Okay.
Item 10.
It may be on.
You
number
make a
4,
mention,
like-
if nothing happens like this, then it will be taken up. Because I was also under impression, suddenly I was reminded, yes, that we have to rise at 3:15. Otherwise, normally, yes.
Yeah, Lordship, item
14, item number, yours is item number?
9, Lordship.
9, Mr. So in person, on his prayer, the matter will be listed again on 14th of November. Yes, next.
Lordship, item number 7. May we come up on 16, Lordship?
Item number 7, what is there, Mr.? Item number 7, some urgency?
Yes, your lordship.
Item number 7 is arbitration?
Yes, Lord.
Arbitration,
Yes.
21, yes, you're there?
I have taken the consent of the other side, lordship, with that.
Okay, let us try,
On
yes,
16.
item number 7, yes,
On
okay,
16.
arbitration, okay,
On
16, okay, on the prayer,
Obliged,
yes.
Lordship, the series, Lordship, I have some difficulty from 10 to 17. After that, any date, Lord.
You tell us then,
21st,
subject to the other learned council,
the earliest date is 21st, Lordship.
21st, huh?
Lordship, item 2, 3 and
21st,
4 is the
21-11.
series.
2 to 4, they are all coming up together, no? 2 to 4,
3 and
2, 3, 4,
Lordship.
2, 3, 4.
That is the series, Lordship.
Ah, sorry?
6,
No, you said your, which one is
2,
yours?
3 and 4, Lordship, that is the series.
2, 3 and 4.
Lordship,
And 5.
it may be taken up next week, Lordship. It's
But your matter is still or not over or what? Yours is
Lordship,
over?
our petitioner's argument is over, Lordship. The
Okay.
respondents were to argue.
Who is the respondent? Huh? So then 5 and 6.
Lordship, I am there, Lordship, item number 5, Lordship.
Huh?
Number 6.
Huh?
I'm for the item number 6.
6, what do you want?
I pray for 21st, Lordship. The earliest date is 21st, Lordship.
2 to 5 is within 4 weeks time.
What we can do is that let 2, 3, 4 be completed, we'll keep reserved.
Lordship.
Then on something like that we have to do, otherwise see, we can't announce in open court. If we have announced open court, see Jayan's case will be decided without hearing. So that is the only strategy we can adopt. If you hear you, keep in cold storage. If my memory proves correct, retains full capacity, then good. Otherwise, something may happen also. We don't know.
Lordship, then next week, Lordship, 2, 3 and 4.
Okay, 2, 3 and 4. So it'll be.
Similar. 5
Huh? So next week.
Next week, Lordship.
Okay, next week.
16-11.
16-11.
2 to 5.
No, 5, I am there. Please, 5, maybe on 21st.
16-11, 2 to 5. And 6,
After 4 weeks.
6, 4 weeks.
So what do you do there? 2 to 6, no?
2 to 5.
2 to 5. 2 to 5. 2 to 5. Make it on
16-11.
16. For you ask somebody to remind us, you will be separated on that day. Otherwise, let it go together. But we will not insist, we will not say that, oh, Miss Jain is absent, we will not reject.
Okay.
Just keep somebody in mind. I will remember so that it can be fixed on the date, which is the preferred date.
The earliest date is 21st, Lordship.
21st. Kindly remind your any friend also to fix. I will keep that.
Okay.
Otherwise, once it is disbursed, see, it may again, I don't know. That is why.
Okay.
Obliged, Lordship.
Yeah.
Okay.